Pronouncement of judgment, item 64.
Writ petition is dismissed.
May I seek my lord's interest? My lord, the matter which had come from my lord, your lordship will recall. It was directed to be listed today for hearing, my lord, but the matter has not come on the list. May I just hand over the order?
No, it's okay. We take it from you.
Great. So, my lord, my only request is, my lords, because sorry, the matter was first taken up by your lordships on 6th, on my lords, 10th of February, then 6th of March. Then 6th of March, your lordship kept it on 11th of March, when again it did not figure in the list. Then we mentioned it, then it was kept for 1st of April. Then because Justice Pathak's bench was sitting for only 2 days, my lord, then he said, my lord, it's better to come in for lordship. So kept it for today. Now it's again not shown on the list. So my request is, my lord, if your lordships could have it day after, my lord, subject to your convenience.
You please give it to the court master. I'll just check up, because what is happening is that I have special bench, and this APSC matters have started. I have started the hearing on day-to-day basis. So we'll examine, and by 2 o'clock we'll tell you when it will be listed. Just give the mention memo. Just give the mention memo. I'm sorry, but I can't organize.
Right. If somehow, I mean, the day after 1 hour, because what I would
There
suggest,
are
your
two
lordship.
special bench which are also slated to come in these days. I'm not aware. Actually, I'm not aware.
Right.
I'll just consult my court master and tell you.
Otherwise, my lord, my request is for day after, and my lord, then continuously, then I will do the matter, my lord, 1 hour, 1 hour. I can finish it in 1.5 hours, anything, and then the other side. It will not, it's a short point, my lord, not very much.
It's okay. But
I'm
please,
grateful. I understand.
again
I'm
at
just
2 o'clock, we'll
I'm indicating to your lordship, you know, how much time. I
at 2
understand.
o'clock we'll.
I'm great.
May I please, Lord? I beg to mention item number 7 of the hearing. So finally, this
Seven,
matter may
we
be
are not adjourning any matter where adjournment slips are not given. Adjournment slip is only available for item number 5. Other matters we are not adjourning.
5 and 63, sir.
5 and
63.
5 and 63. These are the only 2 matters we are adjourning. On Tuesday and Thursday, we are not adjourning any other matter without advance slip. We are just adjourning item number 5 and 40, 63 on the prayer made by counsel. Also, as a representative on the prayer made by counsel to the petitioner. Matter since adjourned to the list after 2 weeks.
in item 5, your lordship, amicus is out of station.
5 we have adjourned.
Yes.
5 and
Maybe
3.
Lordship, in item number 8 and 9, Lordship, my senior Muhammad Lordship, she has gone for voting, Lordship, in Bangaigaon. So finally adjourned.
No, we don't know. We are not adjourning any matters where advance adjournment slips are not given on Tuesdays and Thursdays. We're not adjourning.
Lordship, petitioner already died, Lordship. Oh, help all stuff.
Whatever will be the good reason, we are not adjourning. Let the matter be called, then we'll hear you.
Lordship, item number 63, Lordship. Yesterday I had given adjournments.
Adjourned it, already adjourned.
Lordship, date may be fixed, Lordship.
Fixing it after 2 weeks.
Okay. Lordship, I beg to mention item number 2 for adjournment.
So motion matter, okay.
My lord, my senior's father is hospitalized. Kindly adjourn the matter for 2 weeks.
Allowed 2 weeks, okay.
Allah's my.
Daily list, item 1 for motion.
What is the best document to connect you to your projected parents?
My lord, the voter list is also there, my lord.
No, no, voters list is something we can't consider for the good document for the first time. Any connected documents, any other link document?
My lord, they had exhibited, my lord, land report, my lord.
Which document, which page?
Last will find it in the LCR, my lord, exhibit 6, my lord.
Page,
Exhibit C, my lord, in the LCR.
exhibit 3.
Yes, my lord, exhibit 3. Then document is there, my lord.
Yes.
Jamabandi document. Well, petitioner's own mother as well as uncle as well as Tauguras were also mothers. Close mother.
Which page is your evidence
Evidence.
or written statement, wherever this document is introduced?
Yes, my lord. Page 33, my lord, you'll also will find
Page 30,
33, my lord.
33.
My lord. Is the evidence in chief of the petitioner, my lord.
No, which paragraph is that document introduced? Exhibits.
Paragraph 5, my lord, page 33, paragraph 5.
Mention. Which page is the opinion?
Opinion is 52, my lord, page 50.
Yes, now shows the voters list.
Voters list, my lord. The lordship will find, my lord, page 16, my lord. Here, my lord. Page 60, page 16 is the voter list of 66, my lord. Here, my lord, petitioners, grandfather Mangal Devani and petitioner father Jalil Uddin is there, my lord. Hereafter, your lordship will find page 18, my lord, 1970 voter list, my lord. Here is Jalil Uddin.
Just a moment. Neither in your written statement nor in your affidavit, you have introduced the death of your grandfather. Without death of your grandfather, how could somebody inherit the land? The date is relevant because in 2000 there was a reference against you. The inquiry was there against you, and after that, these mutation orders were passed. In this mutation order, there are three names. One name does not appear in any of the voters list. And what is your explanation for the delay of 5 years?
financial hardship. Paragraph 21.
Yes,
Paragraph 21.
paragraph
21, madam. Please,
21.
12, madam.
But that's not a ground. No statement at all.
Another aspect of the matter, my lord. If lordships go through the recording of deposition, my lord, annexure I, only lordship will find, my lord, the post examination through court, my lord, it was by the criminal member, my lord.
Which page?
Page 36, my lord.
36.
My lord.
Yes.
Form of deposition, my lord. This is a post examination through court, my lord.
We are not getting you. Please speak loudly.
My lord, this is the form of recording of deposition, my lord.
Yes, yes.
My lord, your lordship can, this is the questionnaire, my lord. It was.
Yes, yes, we've seen that.
It's for the court, my lord.
No, but you are projecting that you were poor for which for 5 years you could not file it.
My
It's a very vague statement. It's not your case that earlier you were poor and then you could not file it and now you had a windfall income and therefore you are filing it now. That's not your case. So
single event was here. After this plan, after this mission.
We can give you an opportunity to improve your, to take an appropriate stand. But this is something very vague. On this basis, and we are giving you that liberty because there are some documents which may help you, but this condemnation of the explanation of delay must be adequate. File an affidavit, we give you an opportunity. We give you 2 weeks time, you'll be able to do it?
Fine.
Okay. All sides are represented. Now the prayer made by Mr. S. Hogland, counsel for the petitioner. Matter stands adjourned today to enable him to take updated instructions and address the court on the issue of delay of 5 years in approaching in challenging the impugned opinion. Next para, list after 2 weeks.
Surprise.
Item 3 for admission.
You were last referring to People's Union, People's Union of for Civil Liberties.
Fine.
You're citing any more cases?
Yes,
No.
that list I
Yeah, middle list.
yes,
Nothing more to say?
if for my learned colleague.
Reply. Okay.
Well, prior to my last order, it shows that I did not appear, madam. Maybe in an advertisement.
Last order.
Yes, madam.
Heard Mr. H. Chaudhary. First
Okay.
line is heard Mr. H. Chaudhary.
The last, my lord. I've just checked up my,
Huh?
I've just checked the online, it shows my.
I don't know. Check up this.
I'll check up later on, my lord. Just, I'm just letting you.
24 votes. Okay, yeah, it was. Hey, Raji. ভুল হয়েছে তুমি চেক করো রাখি মাটি আমি চেক করো যাতে হার্ড মিস্টার এই চৌধুরী একটু কাছে মনে পিয়ার্স মাটি আমার সাইড অফ দ্য কানেক্টর আছে One zero nine eight. First part of the list. 724. You're right. There is a mistake in the records. There are two orders in the two files of the court. Some mistake has happened. We're just checking it. In the first file, this is the order.
No, it's okay.
No, please check it because we have to correct it. Ultimately, it's a code of record. We have to correct the records. Because it can't be that I have heard him and my
That's right.
esteemed sister has not heard it.
I just checked up what the was.
No, you are right. Yeah, thank you for pointing it out.
It's okay. Fine. Thank you.
Yeah, sorry this happened.
Sometimes.
Yes. Yes.
But may I please, Lordship? Lordship, may I kindly take up the writ petition? The record I have seen, the case diary, a copy of the case diary, Lordship has given me. I have checked up. In fact, my learned friend for the additional APP whom the Lordship has requested to assist the Honorable Court, they have all apprised the Honorable Court. Some statements of the witnesses are there. Those are vital. I'll take your Lordship to that. But basically, my respectful submission before this Honorable Court is that this is an encounter. They said that this is a fake encounter. It's a stage encounter, and ultimately he was an innocent common man, and he was killed by police. And our case is that he is a part of a terrorist organization, and he was killed in an encounter. But kindly, I'll start with the writ petition, what they have projected, Kindly come to the writ petition, at page number 5, paragraph number 2. Some of the paragraphs, I would like to read because this is the projection made before the Honorable Court. And two persons, they have named from the version of those two persons, ultimately a doubt has been arose, and the entire thing has started. Paragraph number 2, that the petitioner happens to be the elder brother of one Ratan Narzari, alias Ratna, who was a cultivator by profession, and he was looking after his family consisting of his wife and 3 children through agricultural means. And it is stated herein that the brother of the petitioner was an overgrown family man, having no connection whatsoever with any extremist organization, and more particularly with NDFB-S. That is their case. Then, in paragraph 3, they said that on last 27/12/2016, his brother, namely Ratan Narzari, received a phone call from a person named Jagat Brahma Jaiklong of village number so and so at around 4 p.m. This date and the person who called at 4 p.m. Jaiklong, this is important. That is why I have indicated this Jagat Brahma. His statement is also there in the record. And accordingly, he left home towards Bangtol Bazaar with his motorbike. This motorbike is also important. This has a bearing registration number so and so to pick up the aforesaid Jagat Brahma Jaiklong, and since thereafter he did not return home. That is their case on 27/12 at 4 p.m. Then he said that on the next day, that is on 28/12/2016 in the morning at around 8 a.m., the wife of Ratan Narzari, Sarabati Narzari, got an information that her husband has been killed by the Indian Army in a fake encounter at a place under the jurisdiction of Bisumari Police Outpost of Kokrajhar Police Station. Then they said that immediately after receiving such information, in paragraph 5, they said that their family members rushed to the Kokrajhar police station, wherein they come to know that the petitioner's brother is already dead, and later on, after completion of post-mortem and other formalities, the dead body was handed over to the family members of the petitioner. It is pertinent to mention herein that on a mere look at the dead body of the brother of the petitioner, it was seen that he has sustained gunshot injuries in vital parts of his body, which resulted possibly in his instantaneously death, and it is a clear-cut case of cold-blooded murder taking the guise of a fake encounter. Now the allegation came. Then on next para, on 28/12/2016, his sister-in-law, that is the wife of late Ratan Narjari, namely Sarabati Narjari, lodged an FIR before the in charge of the Bangtol outpost as regard killing of her husband by the Indian Army, taking the help of one Jagat Brahma. They said that by taking the help of Jagat Brahma, her husband was killed. On receipt of the same, the in charge of Bangtol outpost entered Bangtol outpost GD entry number 6620 dated 28/12/2016 and forwarded the same to the officer in charge of Runikata police station for registering a case in proper section of law, and accordingly on receipt of the same, the officer in charge of Runikata police station registered Runikata PS police station case 68/2016 under section so and so. This Runikata subsequently we have placed on record that it was after the honorable court order, the learned court below's order, it was transferred and a Kokrajhar PS was registered subsequently. It was investigated. Then paragraph 7 is important, my lord. Now that is the fact. That is the fact that the wife of the deceased came to know that she was killed by so and so, and accordingly after the FIR was lodged. Now they said that later on, it could be learned that late Ratan Narjari had left behind one of his friend, namely Susan Narjari, and went with his motorcycle for some work. And it was the last time he was seen alive, as he was found missing since then. Thereafter, on the same day evening, two persons, namely Motir Bosumatari and Manoj Bosumatari, on their statement, they are relying, the petitioner is relying. Motir Bosumatari and Manoj Bosumatari, both ex-NDFB member, who were traveling in a motorcycle, saw a white Bolero without any number plate on the road near a school after crossing Bangtol Bazaar on the way towards Bamungao, and they saw army personnel and Ratan Narjari in civil dress sitting inside the vehicle. Both the persons crossed the vehicle, and after some time, the Bolero vehicle overtook them, and after driving for some time, they met Jagat Brahma, Jaiklong, and Rodai, who were also driving a motorcycle and talked for some time, and thereafter all of them drove towards Bamungao, wherefrom they proceeded on separate ways. Subsequently, the aforesaid Motir Bosumatari and Manoj Bosumatari could realize that the motorcycle ridden by Jagat Brahma, Jaiklong along with Rodai was in fact the same motorcycle which belonged to Ratan Narjari. Then, my lord, as regard the whole incident on 28/12/2016, the in charge of Bisumari PP lodged an FIR before the officer in charge of Kokrajhar police station, alleging inter alia that on specific information, a joint operation was launched by Kokrajhar police and himself and 7 6th LI so and so of Runikata regarding involvement of NDFB cadre in Laupani area, and 3-4 suspected cadres were moving towards the ambush party and started indiscriminate firing upon the operational team, and in self-defense and for protecting government property, the team also opened controlled retaliatory firing, which lasted for 20-25 minutes, and thereafter one injured militant was found severely injured and other cadres managed to escape. The injured militant, we said, he is the deceased, he is Ratan. Later on, the militant succumbed to his injuries and he was identified as Ratan Narjari, Ratna, and several arms and ammunitions were recovered from his position as well as from place of occurrence. And on receipt of the FIR, Kokrajhar police registered Kokrajhar PS case number 734/2016. Here, my lord, after investigation, charge sheet has been filed. That is already placed before your lordship, my lord. Now, on these facts, my lord, their case is, my lord, kindly come to paragraph 10. They said that the entire incident is a barbaric and illegal action of killing of Ratan Narzari. Paragraph 10, they said that immediately after the whole occurrence, on the next day, the army and police personnel of Kokrajhar police station claimed that Jaiklong Gaura Brahma alias Jagat of New Basbari under Kokrajhar police station was apprehended being a terrorist of NDFB along with arms and ammunition, and he was involved in several cases of extortion, providing support and information regarding movement of security forces to the ban organization. Although it is a fact that the aforesaid Jaiklong alias Gaura Brahma alias Jagat is an ex-NDFB member and he was an overground person, which is known to all, and the police and the army personnel have planted the whole story of his apprehension only to save their skin. Since Jagat Brahma was the person instrumental in calling the deceased Ratan Narzari. Then they said, my lord, in paragraph 11, they said that as a result of the whole incident, thousands of public of so-and-so came out spontaneously to protest and raise their voice against the barbaric and inhuman action of killing an innocent cultivator who was a family man having his wife and 3 children in a fake encounter. And even the police personnel of the Sirang district have also made statements that no document as regard involvement of Ratan Narzari Ratna with any unlawful or illegal organization is available at the hands of the police personnel of Sirang district, and even representation before the deputy commissioner so and so have been filed. They said, my lord, in paragraph 12 that the Ratan Narzari, my lord, in paragraph 12 they said that the government Gambhura have also certified that Ratan Narzari was a cultivator having his family and has a regular voter having casted his vote from 97 to till 2008, 14, 2015, 2016, and also certified that Ratan Narzari was known to him from childhood and he was in no way connected with any illegal organization, as he was called by Jagat Brahma from his residence and thereafter killed by the Indian Army and police personnel, alleging him to be NDFB member. Therefore, my lord, in paragraph 14, they said that the entire incident of participation of the Assam police personnel in the illegal death of the deceased need to be investigated by us, not be investigated by Assam police, as there is every possibility to partisan investigation to shield its own personnel. Kindly come to little later towards the end of the paragraph, they said that moreover, there is a serious apprehension on the part of the petitioner that the family members of the deceased as regard the life and liberty of the 2 witnesses, namely Motir Bosumatari and Manoj Bosumatari, who had last seen the deceased in a vehicle along with the army personnel, and accordingly both of the above witnesses may be provided with adequate security because they are relying on their security so that nothing untoward may happen to them. They are relying on their evidence. That is why they said, and accordingly, my lord, they have prayed that the entire incident of killing of the person is as stated by police is not correct, and it is an illegal killing, and accordingly they prayed that the investigation should be given to the CBI or a high court monitored special investigation team should be constituted. My lord, kindly come to page number 27, my lord. This is the GD entry, my lord. At page number 27, Annexure B, this is the GD entry of the Bishumari police point by GD entry number 481 dated 28/12/2016. But this said at night about 10 p.m. the additional SP headquarters Kokrajhar along with his staff arrived at outpost and left along with in charge and staff. The entry says, my lord, the additional SP headquarter along with his staff present in this outpost and informed that a group of extremists belonging to unlawful organization NDFBJ along with sophisticated arms and ammunition in their hands are found moving inside the jungle area of Laupani jungle under the jurisdiction of this outpost, and as per direction I SI Arnath in charge Bishumari along with one section 8 APBN and one section COD battalion accompanied the additional SP headquarters as per his request for conducting search operation in the jungle, and accordingly after entry in the general diary proceeded along with him for conducting search operation in the Laupani jungle area and leaving head constable so and so in the charge of entry. So this is the starting point. And thereafter kindly see page number 29. This is the FIR by the in charge. So calling Ratan Narjari at 4 by Jagat, and he left the home and he was missing. Those are the facts. Those are the story of the petitioner narrated by them. And this is the ultimately starting point at 10. They went out of the police station with their team for in search of the persons, and that is the starting point. In search operation, for conducting the search operation, they went out. With reference to the subject cited above, I have the honor to inform you that based on specific info regarding movement of NDFB as cadres at village Laupani area, a joint operation was launched by Kokrajhar police led by so and so additional SP headquarters Kokrajhar and myself SI Rituraj Nath so and so and 7/6 so and so at around 1:30 hours in general area of Laupani jungle. The operational team reached village Laupani and were lay ambush at two strategic points. One to be laid by additional SP headquarters Kokrajhar and his team, and the other to be laid by me along with team of 8 APBN personnel and one section of commando party. At about 5:20 hours, 3-4 suspected cadres equipped with sophisticated weapons were observed approaching towards west from eastern direction through the jungle track. While observing the suspects who were moving towards the ambush party, they were asked to halt. Immediately, the cadres started indiscriminate firing upon the operational team, finding no other alternative and in self-defense as well as for protection of government property, arms, ammunition, etc. The operational team also opened controlled retaliatory fire. The exchange of fire lasted for almost 20-25 minutes, and after the firing stopped, the operational team waited for 10-15 minutes to observe the area for further movement. Thereafter, the operational team cautiously searched the area and found one severely injured militant lying in the jungle, and other cadres managed to escape, taking advantage of thick forest. Immediately, the militant was evacuated to RNB Civil Hospital, Kokrajhar for his medical treatment, but the on-duty doctor of RNB Civil Hospital, Kokrajhar declared him brought dead at 6:58 AM. Later on, the slain extremist was identified as Ratan Narjari, son of so and so. The following recoveries were made from his possession as well as from the place of occurrence. So these are the recoveries. The seizure list is there in the record. It is available. It must be mentioned here that the slain militant was also an arms supplier peddler who, according to reliable intelligence outputs, had in possession a few deadly arms and hundreds of ammunitions that were of different calibers as per intelligence output from various central and state intelligence agencies. He was also attempting to peddle the ammunitions, arms to the belligerent and arms deprived fugitive Bedai Batha group of the band and DAPS. So this is the FIR. Ultimately, the story is that they were at a particular place, and at around 5:20 hours, the 3-4 suspected cadres, they went they approached through that particular jungle track, and in a retaliatory fire, one militant was he sustained injuries and ultimately he died. The investigation,
Just a moment.
my lord. Yeah. Take care of it. We'll see. And then it is. Five one. ठीक है. Okay. मतलब the
When we refer to a police team, how many persons would be a section? Say a police team goes,
Got it.
we have certain groups in the police. So what is the hierarchy in the groups? How many people would be one section? How many people would be one division? How many people would be one battalion? Are you aware of it? No.
मतलब no, मतलब
Because it may vary from organization to organization.
got it.
Maybe in one police department, you have a section of 6 people. Somebody will have 12. We don't know. So in this 8th Assam Police Battalion and the CDO division who are there, how much would one section would be? Because in the last time when we read this case diary, so far as police investigation is concerned, there is no list of people who are accompanying. The entire team, the description of the team is not available. At least on that day, we could not notice that. It may be available, but we could not notice that.
The statement of the members of the team is there, मतलब, but the total number list as Lordship has indicated, it's I have not seen.
I mean, you see, we flip it so fast that we tend to miss out something. This is a note which I maintained earlier.
मतलब,
How many people would constitute a section and how many people are actually there in field? We wanted to know that also. You may respond it later on.
in the meantime, we'll respond. We'll
Because this, there are 2 inquiries, one by the magistrate and one by the judicial
judicial
inquiry.
Yes, madam.
So I did not notice that. That's why we are asking you.
Correct. Very, very, very. Projection to the Well, the postmortem report and other reports are on record. They have also annexed. Well, I'll take your lordship to that. Well, at a later part. Well, the two persons, Malad, Motir Bosumatari and Manoj Bosumatari, whom Malad they have placed reliance in paragraph number 7, Malad, I have read. The statement of those two persons are important, Malad.
That Manoj and another.
Paragraph number 7, because their projection is paragraph number 7, Malad. That is why I have read on the Lordship may kindly take a note of that.
Yes,
Lordship.
both names are from M.
Yes.
Huh?
They said, my lord, the specific statement made in the writ petition is that, because that creates the first doubt, my lord, that Matir
Bosumatari and
Matir Bosumatari and Manoj Bosumatari, who were traveling in a motorcycle, saw a white Bolero without any number plate on the road near a school after crossing Bangtol Bazaar on the way towards Bamungao, and they saw army personnel and Roton Nursery in civil dress sitting inside the said vehicle. Well, statement of motive and Manoj are available in the record which lordship has, which I have been given. I have seen. Manoj Bosumatari's statement has been recorded in connection with the case registered on the affair of the wife, wife of the deceased. I would like to just read the statement of Manoj Bosumatari. Statement of witness Chief Manoj Bosumatari. More married,
You see, whatever statement they made, can you please come to page 66?
66 of the
Who is respondent 5?
respondent number 5 is Malad.
Superintendent of Police.
SP of yes, Malad. He is SP Sirang, Malad.
Chirang, yes.
Yes, Malad.
Look at paragraph 9 at page 66.
Yes, Malad. I have marked, Malad.
No reply at all. He just copies the statement and then says nothing.
Lordship.
So this becomes an admission.
The witnesses, namely, he said, the witnesses, namely, so and so and so and so, they were traveling in a motorcycle without number plate. Civilian inside, they noticed them.
Because this affidavit was filed on 4/4/2017. By
Yes.
then, that statement was already recorded.
Yes.
So this Superintendent of Police files an affidavit without even consulting the case diary.
Malad, one thing, Malad, I have seen, Malad. Here he said, Malad, what I would like to, I'm trying to place before your lordship is that the Manoj Bosumatari in his statement has not said that in the white vehicle, inside the white vehicle, he has seen Roton Nursery.
We understand, but you
Here
see,
comes
it's an authority of highest authority in the district in police. Superintendent of Police is filing an affidavit. He files an affidavit without consulting the case diary. Now you are trying to defend the case diary, entries in the case diary by saying that the witnesses said so.
Well, the witnesses also here also in this statement, if I'm allowed to read, Roton
we'll
Nursery,
permit you to read.
Roton Nursery is not
But
there.
there's a question. You see, what happens when there is when there is certain materials in the case diary, and a statement made in the writ petition. So how would we weigh that? Because here this is not a case of denial that no, this statement was incorrect because his statement says so. Therefore, the credibility you will have to establish in this affidavit also.
Correct, Malad, correct. That's true. Malad, what I am trying to point out, Malad, in paragraph 9 of the affidavit of the respondent number 5, he reiterated the statement, but he has not said that Roton Nursery was inside the vehicle. He was seen by these two witnesses. Kindly, Malad, permit me to read the particular part of that affidavit. The paragraph 9, Malad, of the respondent 5 affidavit, the witnesses, namely one Motir Bosumatari and Manoj Bosumatari, stated that on 27/12/2016 at 5 p.m., when they were traveling in a motorcycle towards Bamungao side and a white color Bolero vehicle without number plate with some civilians inside was noticed by them. On the road near Bangtol HS and one Jaiklong was seen riding a motorbike behind the Bolero, which was followed by another motorbike ridden by Radao near Bathau Mission Tinali Bangtol and Roton Nursery was not seen by them. He said that Roton Nursery was not seen by them, the witnesses.
Okay.
Motir Bosumati and Manoj Bosumati did not see the Roton Nursery, the victim. And the statement made in the writ petition is that Motir and Manoj Bosumati has seen the Roton Nursery inside the vehicle in civil dress.
Okay.
That is the discrepancy
Okay.
with army in civil dress. That is the specific case made in the writ petition.
Okay.
And if Lordship takes up the evidence of the Manoj and Motir, it is in the same line of with the affidavit of paragraph number 9.
Yes, now we'll look into it.
In fact, they have said that Rotan Nursery, they have not seen Rotan
No,
Nursery.
it's okay. Once you have shown that, now we'll read that statement.
Lordship. But they said, statement of Manoj Bosumati, more namu thikona upor.
You are reading from where?
I'm reading from this is the diary.
Okay, diary. Okay.
Lordship.
Please read. We are following you.
Lordship. Statement of witness Manoj Bosumati, son of so-and-so. মোৰ নামো ঠিকনা ওপৰত উল্লেখ কৰা মতে সত্য বৰ্তমানে মোৰ বয়স 27 বছৰ মই NDFB RD গ্ৰুপৰ হওঁ বৰ্তমান সিজফায়াৰ গ্ৰুপত আছো মোৰ কবলগীয়া এই যে যোৱা 27/12/2016 তাৰিখে মই আৰু মতি আৰু মই মটৰচাইকেল লৈ বেংটল সোয়েনসো পৰা বামুনি গাঁৱলৈ যোৱা অৱস্থাত আবেলি প্ৰায় 5 মান বজাত বেংটল HS স্কুলৰ ওচৰৰ ৰাস্তাত এখন বগা নম্বৰ প্লেট বিহীন বলেৰো গাড়ী ৰৈ থকা দেখা পাওঁ আৰু গাড়ীখন
What is the date of that statement recorded in the case diary?
This statement is on 5/1/2017.
5/1/17. Okay.
5/1/17. Incident on 28.
No, it's okay. Please proceed. We are trying to find out here
Lordship.
in our copy. Yes. Please proceed.
Lordship. আৰু গাড়ীখনৰ ভিতৰত কেইজনমান চিভিল মানুহ উঠি থকা দেখা পাওঁ আমি মটৰচাইকেলেৰে গৈ থকা অৱস্থাত নৱনিৰ্মিত বেংটল গাৰ্লছ হোষ্টেলৰ ওচৰৰ ৰাস্তাত জগত ব্ৰহ্ম এলিয়াছ জাইক্লঙক এখন মটৰচাইকেলত গৈ থকা দেখা পাওঁ আৰু তাৰ অলপ পিছতে আন এখন মটৰচাইকেলত ৰেডাও লগ পাওঁ জগত আৰু ৰেডাও NDFB এছৰ সাৰেণ্ডাৰ হয় আমি দুয়োজনে জগত ব্ৰহ্মক যোৱা 27/12/2016 তাৰিখে বেংটলত দেখা পাওঁ যদিও ৰতন নাৰ্জাৰীক দেখা পোৱা নাছিলো মোৰ কবলগীয়া ইমানেই then malot another 68 first case then malot the next statement is of Moti Bosumati. Here it is said Moti Balot, son of Deben Bosumati. মোৰ ঠিকনা নামো ঠিকনা ওপৰত উল্লেখ কৰা মতে সত্য বৰ্তমানে মোৰ বয়স 27 বছৰ মই NDFB RD গ্ৰুপৰ হওঁ আৰু বৰ্তমানে সিজফায়াৰত আছো মোৰ কবলগীয়া ইমানেই যে যোৱা 27/12/2016 তাৰিখে সোয়েনসো আৰু মই মটৰচাইকেলেৰে বেংটলৰ পৰা বামুনগাঁৱলৈ গৈ থকা অৱস্থাত আবেলি প্ৰায় 5 মান বজাত বেংটল HS স্কুলৰ সন্মুখৰ ৰাস্তাত এখন নম্বৰ প্লেট বিহীন বগা বলেৰো গাড়ী ৰৈ থকা দেখা পাওঁ আৰু গাড়ীখনৰ ভিতৰত চিভিল মানুহ উঠি থকা দেখো আকৌ অলপ আগত গৈ বেংটল গাৰ্লছ হোষ্টেলৰ বিল্ডিঙৰ সন্মুখত ৰাস্তাত জগত ব্ৰহ্ম উৰফে জাইক্লঙক মটৰচাইকেল এখনত দেখা পাওঁ আৰু তাৰ অলপ আগত ৰাডাওক আন এখন মটৰচাইকেলত দেখা পাওঁ কিন্তু সিহঁতে কি উদ্দেশ্যে আহিছে মই নাজানো দুইজন NDFB এছৰ সাৰেণ্ডাৰ হয় দুইজনক দুইখন মটৰচাইকেলত বেলেগে দেখা পাওঁ ৰতন নাৰ্জাৰীক আমি দেখা নাই So my lord, the very basis of the statement of the petitioner at paragraph 7, they lot.
Mr. Nath,
My lord.
in fact, I wanted to search and get the information of the requirements under the requirements of the state as to the procedure which is required to be followed for doing a postmortem. Please try to get a copy of the prescribed procedure, the updated one which the state has for our personal reading.
My lord.
We just want to upgrade our knowledge. Because nowadays these new things have come for video photography and all those things.
Small.
Those requirements are there. So what actually is the current requirement under the state?
I'll take.
We are not in a hurry. 1 or 2 days you can.
In fact, my lord, I have in 2-3 cases I have my lord, come across. They used to do the videography and all these things are there.
No, doing is one thing, but what is the actual
Guideline.
requirement?
Lot.
Then only we will find out
Lot.
whether it is followed or not.
Follow. Follow. I'll do that. My lord. So, my lord, my respectful submission is that the very basis of their raising a doubt in the incident as raised in paragraph number 5 is not my lord, is baseless. My lord. Say. My lord, the affidavit of the respondent number 5, na, he is the SP of he is the deputy DSP of DSP headquarters of Sirang. In fact, he has paragraph number 4, Lordship has read already 9. In fact, he said that paragraph number 4, my lord, he has indicated that as per intelligence output received from SB headquarters Assam, white signal number so and so, and one Roton, a Bodo person has offered to sell so and so, so and so. These are the statement they have indicated that he is involved in some dealings, my lord. I would like to take your lordship to the affidavit of the respondent number 6 because this is important, my lord. Affidavit of respondent number 6. Kindly come to the affidavit, my lord.
Respondent number 6.
Respondent number 6.
He does not say anything about that incident. He says that it's beyond our jurisdiction.
That's true. That is why, my lord, I have my lord, only, my lord, the vital thing is 4 and 9 because 9, my lord, in response to the paragraph number 7 of their affidavit, he said that they said that so and so has said that in white vehicle, Bolero vehicle, they saw Ratan. That is in fact not correct. That is baseless, my lord. That is why, my lord, I have indicated that affidavit. But here the
Affidavit of respondent number 6.
respondent number 6, my lord, he is SP Kokrajar.
Yes.
Paragraph number 4, that the deponent states that as per intelligence output received from SB headquarter number so and so, the NDFBS cadre Bansao camping with Bedai had contacted one NDFBS linkman late Ratan Narzari, cell number is given, regarding ammunition. According to that input, this is Ratan kept 1,000 rounds of live ammunitions, of which 300 are AK rifle ammunition and 700 are M16 rifle ammunitions. This 300 AK rifle and 700 M16 ammunitions, Lordship may kindly take a note, because one of the witness in his statement, he has indicated these things. I'll take your Lordship to that. As per another intelligence output received from SB headquarters Assam, white signal number so and so dated 26/12/2016, NDFBS cadre Khause, operating from Nagaland, was monitoring the procurement of arms ammunitions for NDFBS. Khause contacted deceased Ratan Narzari, who was using cell phone number so and so for finalizing deal regarding supply of ammunition for NDFBS. Late Ratan Narzari assures Khause to supply 300 rounds of AK rifle ammunition and 600 rounds of M16 rifle ammunitions. As per the investigation report of the independent IO, Inspector Mahesh Chandra Adhikari, CI Simla, District Baksa, also found that this is Ratan Narzari so and so was a linkman of NDFBS and had contact with NDFBS extremist leader G. Bedai Khause and Basau using cell phone number this. So and so. From the above findings and available material evidence, it is crystal clear that the deceased Ratan Narzari was an arms supplier who was also attempting to smuggle the ammunitions, arms to the belligerent and arms deprived fugitive Bedai Bata group of banned NDFBS organization. Hence, the statement given by the petitioner is not true. Then, in paragraph number 6, he said that based on specific input and reliable sources regarding movement of NDFBS cadre at village Laupani area, a joint operation was launched by Kokrajhar police and 7/6 so and so at about 1:30 hours in general area of Laupani jungle. At about 5:20 hours, 3-4 suspected cadres armed with sophisticated weapons were observed approaching towards the operation team. They were first asked to stop, but instead they opened indiscriminate fire upon the operational team. Finding no other alternative and in self-defense as well as for protection of government property, the operational team also opened controlled retaliatory fire, and as a result of which slain militant Ratan Narzari died. Hence, the allegation that the militant was killed by Indian Army in a fake encounter is not true and totally denied. Then kindly come to paragraph number 12, my lord. The allegation of made in paragraph number 8 is also denied. I'll take your lordship to paragraph number 12, that the deponent states that it is a fact that on 28/6/2016 at about 2300 hours, Jaikhong Gaura alias Jagat was apprehended being terrorist of NDFBS from Audang Bazar, and he led the joint operational team to nearby forest to the recovery of 1 rifle, countryman, and 2 numbers of so and so round magazines at 23:30 hours, which were hidden by him. Well, it is on the next day. This refers to Kokrajhar PS case number 737 of 2016. 737 was registered subsequently because the case which the incident relates to 734 of 2016. The 737 came in the next day. Under section so and so, under section 120B and so of the IPC read with section 25A1 of the Arms Act, complainant of which is Bhairav Prasad Acharya of 3 Rajput Camp, Sarfanguri. So this was lodged by Bhairav Prasad Acharya of 3 Rajput Camp, Sarfanguri. Hence, it is crystal clear that the above mentioned Jaikhang alias Gaura Brahma alias Jagat was out of reach of the operational team during the encounter, as well as the police of as well as the police of Kokrajhar district. Hence, the question of making him the person instrumental in the encounter as in encounter case as alleged in this para does not arise at all. So they have now projected that we made him instrumental. The Jagat was instrumental in the incident of the alleged encounter. That is not correct, Malad. Malad, then kindly come to
Just a moment.
Malad. Paragraph 15, Malad. The deponent states that the incident was that of an encounter between armed NDFBS cadre, including the slain militant and the operational team involving heavy exchange of fire between both sides. Bullet may hit any part of the body. Hence, the allegation made in this paragraph is not tenable. We denied that, Malad. Then kindly come to paragraph 22, Malad. That the deponent states that as claimed by the petitioner to issue show cause upon the respondents will not be justified as an act of encounter was as per law as stated above, and it will also send a wrong message to common peace loving people as well as the surviving family members of the victim who were killed by the banned extremist organizations. But they said that as per number 1, as per guidelines of the NHRC, New Delhi number so and so dated 12/5/2010, the instant case has already been entrusted for investigation by an independent investigation officer wide number so and so dated 6/1/2017 of the Additional Director General of Police Railway come IGP BTAD Assam Kokrajhar. As a part of scientific investigation, all the seized exhibits, arms and ammunition have already been sent to the Forensic Science Laboratory, Assam Kahilipara, for examination of the same by expert wide memo number so and so dated 2/1/2017. Immediately, my lord. The hand swab, this word is wrongly typed, my lord. The hand swab of the deceased has also been sent to the Forensic Science Laboratory, Assam Kahilipara, for examination of the same by expert wide memo number so and so dated 2/1/2017. Copy enclosed, they said, but I did not find a copy, my lord. There is a typographical error, but the entire thing is in the record, my lord. Moreover, on request of the district police, Kokrajhar, wide memo number so and so dated 30/12/2016, the district magistrate Kokrajhar has also passed an order wide memo number so and so dated 31/12/2016 to conduct a magisterial inquiry by an additional by ADC Kokrajhar. Then number 2, they said the respondent humbly submit that the incident of encounter was a lawful action on the part of the law enforcing agency. Then, my lord, they said the respondent humbly submits that the slain militant Ratan Bosumotari was an arms supplier who was also attempting to smuggle the ammunitions arms to the belligerent and arms deprived fugitive Bedai so and so, and the use of those arms and ammunitions could have taken thousands of innocent lives if used by the aforesaid organization. Hence, such a terror act, they said, it is against the society and if encouraged with compassion. The forensic reports, postmortem report, and the hand swab report, the Lordship has already seen, Malad. Here, Malad, in the record, I have seen one more statement. Kindly permit me to read this, Malad. This is Jaikhang Gora Brahma, Jagat. This statement was taken on 10/1/2017. Well, he said that মোৰ বয়স বৰ্তমান 29 বছৰ মই খেতি বাতিও ব্যৱসায় কৰোঁ মোৰ এখন মহিন্দ্ৰা 4 cylinder so ট্ৰেক্টৰ আছে আৰু ট্ৰেক্টৰ নিজে চলাই ভাড়া মাৰো ৰতন নাৰ্জাৰীৰ লগত ব্যৱসায় সূত্ৰে যোৱা 11 চনত চাচিনাকি হয় ৰতন আৰু মোৰ মাজত ঘৰুৱা অহা যোৱা আছে তাৰ লগত মই ফাৰ্মলেণ্ডৰ ৰাস্তাত কাম হওঁতে একেলগে চৰকাৰী কাম কিছুমান কৰোঁ দুইজনৰ মাজত টকা পইচাৰ লেনদেনো হয় সি মোৰ পৰা কোনো পইচা পাবলগীয়া নাই আৰু ময়ো তাৰ পৰা কোনো পইচা পাবলগীয়া নাই যোৱা 16 চনত নৱেম্বৰ মাহত দ্বিতীয় সপ্তাহত ৰতন নাৰ্জাৰী আমাৰ ঘৰত আহে আৰু সি তাৰ লগত 300টা AK সিৰিজৰ গুলি আৰু 600টা M16ৰ গুলি থকা বুলি কয় সি মোক উক্ত গুলিখিনি বীৰবাই ওৰফে বীৰমল খাং so থানা so আৰু मतलब this I could not read it so সমজাই দিয়াৰ কথা কয় বীৰবাই আৰু খাও like this I just could not pronounce it NDFBৰ স্থায়ী সদস্য নহয় ৰতনে যেনে তেনে উক্ত গুলিসমূহ মোৰ ট্ৰেক্টৰেদি গোবৰৰ তলত লুকুৱাই নি কোকৰাঝাৰ থানাৰ অন্তৰ্গত বাৰবাৰীত সিহঁত দুটাৰ হাতত সমজাই দিয়াৰ বাবে অনুৰোধ কৰে ৰতনৰ অনুৰোধ মই মানি লোৱা নাছিলো সি এই কামটো খ্ৰীষ্টমাছৰ আগত যেনে তেনে কৰিবলৈ কয় যোৱা ইংৰাজী 23/12/2016 তাৰিখে ৰতন নাৰ্জাৰী মোৰ ঘৰলৈ আহে আৰু লগত প্ৰায় 28-29 বছৰীয়া এজন অচিনাকি ব্যক্তিৰ লগত আহে ল'ৰাজন বড়ো ল'ৰা হয় ৰতনে সেইদিনা এখন সিম কাৰ্ড মোক দি যায় মই ইংৰাজী 24/12/2016 তাৰিখে ৰাতিপুৱা প্ৰায় 9-10 বজা মানত ভাৰিগাঁও বজাৰত আহি মোক লগ কৰে আৰু তাৰ সৰু ছোৱালীজনীও আছিল আৰু মোক এটা মোবাইল হ্যান্ডসেট দি যায় দুয়োদিনে সি মটৰচাইকেল লৈ আহিছিল ৰতনে মোক মোবাইল আৰু সিমখন সেইদিনাৰ পৰা ব্যৱহাৰ কৰিবলৈ কয় মই ৰতনে দিয়া মোবাইলটো সিম কাৰ্ড ভৰাই ব্যৱহাৰ কৰোঁ যদিও ৰতনে মোক ফোন কৰা নাছিল ৰতন নাৰ্জাৰীয়ে মোক মোবাইল দিয়াৰ পিছদিনা অৰ্থাৎ 25/12/2016 তাৰিখে ৰাতিপুৱা 9 মান বজাত এটা মেছেজ মোবাইলটোত আহে আৰু মেছেজটোত ককাইদেউ বুলি সম্বোধন কৰি মাইৰাং গুলিৰ খবৰ ভাল আৰু মোবাইলটো খুলি ভালেই কৰা বুলি মেছেজ দিয়ে আকৌ ইংৰাজী 26/12/2016 তাৰিখে NDFB এছৰ অচিনাকি সদস্যই ৰতন নাৰ্জাৰী দিয়া মোবাইলটোত কথা পাতে তেতিয়া মই নিজকে ৰতন নাৰ্জাৰী নহয় বুলি কোৱাত ৰতনৰ মোবাইল নাম্বাৰ বিচাৰে আৰু মই ৰতনৰ নাম্বাৰটো দিওঁ তেওঁলোক দুজনৰ মাজত কি কথা হ'ল মই নাজানো কিছু সময় পিছত আকৌ NDFBৰ সদস্য খাওয়ে মোলৈ ফোন কৰি জৌদাওক বিচাৰিবলৈ কয় কাৰণ জৌদাও ইতিমধ্যে NDFB এছৰ সংগঠন এৰি পলায়ন কৰিছে আৰু নিজ কাঠলিৰ বাছবাৰীৰ এলেকাত আত্মগোপন কৰি আছে মই কামটো কৰিবলৈ নোৱাৰিম বুলি কওঁ মই জাউদাং আৰু খাওক চিনি নাপাওঁ যদিও তেওঁলোকৰ ঘৰ ঝাৰবাৰী এলেকাত হয় বুলি জানো খাও মোক গুলিৰ কথাও সোধে আৰু সোনকালে হেণ্ডঅভাৰ কৰাৰ কথা কয় আৰু বীৰবাৰ লগত আলোচনা কৰাৰ বাবে কয় তাৰ কিছুদিন পিছতে NDFB সংগঠনৰ সদস্য বীৰবায়ে ফোন কৰে আৰু গুলিৰ কথা সোধে মই 900টা গুলি থকা কথা জনাও আৰু গুলিকেইটা দূৰত থকা বুলি জনাও যোৱা 26/12/2016 তাৰিখ ৰাতি 9টা মান বজাত কোকৰাঝাৰ পুলিচ আৰু আৰ্মি মোৰ ঘৰত আহে আৰু মোক বিচাৰে সেইদিনা মই ঘৰত আছিলো যদিও সুযোগ পাই পলায়ন কৰোঁ মই আগৰ পৰাই অনুমান কৰিছিলো যে জংগলী পাৰ্টিৰ লগত কথা পতাৰ বাবে পুলিচ আৰ্মিয়ে মোক বিচাৰিব পাৰে আৰু মই সতৰ্ক আছিলো সেইদিনা পুলিচ আৰ্মিয়ে মোক বিচাৰি পোৱা নাছিল যদিও মোৰ ৰতন নাৰ্জাৰী দিয়া মোবাইল নম্বৰটো পাই মোৰ ড্ৰয়াৰত লিখি দিওঁ মোৰ ড্ৰয়াৰত ৰতন নাৰ্জাৰীয়ে দিয়া মোবাইলটো পাই পুলিচ আৰ্মীয়ে লৈ যায়। মোবাইল নম্বৰটো মোৰ মনত নাই। মই ঘৰৰ ওচৰতে আত্মগোপন কৰি খোৱা বোৱা ঘৰতে কৰিছিলোঁ। মোৰ দেউতা ভিডিপি ছেক্ৰেটাৰী হয় আৰু দেউতাৰ পৰামৰ্শ মতে যোৱা 28/12/2016 তাৰিখে পুলিচৰ হাতত ধৰা দিওঁ আৰু বাৰিগাঁও আই চি এ আহি মোক ঘৰৰ পৰা ৰাতিপুৱা 10 মান বজাত লৈ যায়। মই মোবাইল নম্বৰ ছ আৰু অন্য এটা নম্বৰ ব্যৱহাৰ কৰিছিলোঁ। আন নম্বৰটো মোৰ মনত নাই। দুয়োটা চিম এটা মোবাইল হেণ্ডছেটত ব্যৱহাৰ কৰিছিলোঁ। পুলিচৰ হাতত ধৰা দিয়াৰ সময়ত মোৰ লগত কোনো অস্ত্ৰ শস্ত্ৰ নাছিল। এইটো কি? কাৰিগাঁও আৰক্ষী চকীৰ পৰা মোক কোকৰাঝাৰ থানাত যোৱা 29/12/2016 তাৰিখে ৰাতিপুৱা 9 মান বজাত লৈ যায় আৰু তাতে মোৰ ফটো লোৱাৰ সময়ত এটা ডাঙৰ হাথিয়াৰ লগত দিয়ে। হাথিয়াৰটো কি আছিল মই নাজানো। কোকৰাঝাৰ থানাৰ পৰা মোক কোৰ্টলৈ লৈ যায় আৰু পুনৰ কোকৰাঝাৰ থানালৈ লৈ আহে। So this is his statement as regard Ratan Narjari. My lord, by referring to this statement, my respectful submission before the honorable court is and lastly, my lord, he said that যোৱা 28/12/2016 তাৰিখে আবেলি আৰক্ষী চকীত থকা সময়ত আবেলি প্ৰায় 3 মান বজাত ৰতনক আৰ্মীয়ে এনকাউণ্টাৰ কৰা বুলি শুনিলো আৰু উক্ত ঘটনাত মোকো জড়িত থকা বুলি প্ৰচাৰ চলোৱাৰ বিষয়ে জানিব পাৰো। So this is his statement, my lord.
You have just read the evidence of, the affidavit of Rajan Singh, respondent number 6. Now, please read this page 33. We are sending you from here. Done.
33 record of a meeting.
Only 7-8 lines. Please read it, then you'll come to know. Now, this document is the, what do you call, independent, what do you call, independent investigation report. Now, according to this report, in the first 10, about 7-10 lines, we find that the operation was led by Srinath T, Deputy Superintendent of Police, right?
Srijit T IPS, Lordship.
Yes. Now, please come to this affidavit of respondent number 6. He says, I led it. I led the joint operation team. Page 73, paragraph 12.
Well, the affidavit of respondent number 6, no?
6,
6,
para 12.
para 12. It is a figure that at about so and so was apprehended in so and so. The deponent said that it is a fact that on so and so at about so and so was apprehended being a terrorist and so from so and he led the joint operation team.
Yes.
The SP. In fact, SP.
Yes, because
he led.
since you were reading it, we were following you.
Actually, the additional SP headquarter, because the GD entry also said that it is the additional SP.
That's why we are asking you. They can't be two operational heads.
No.
Last time also we questioned it because of the fact that in the affidavit of the army, they said that we were not part of it.
No.
And then, having known the protocol for some reason, we understand that once there is a joint operation team, there will be a meeting of mind of two authorities, because the issue would be who would lead the team.
Correct.
There can't be more than one team leader in a joint operation. This is where we were there on the last occasion. Now, when you were reading this, then you find that this appears to be inconsistent with the joint investigation. What is that?
The GD
Special
entry.
investigation, what
Yes,
is it?
yes.
Independent investigation.
Independent investigation. Well, in fact, independent investigation report, the GD entry and the FIR filed by the police. It indicates that the additional SP headquarter, Kokrajhar, he was there. He was the leader.
This affidavit is again, you have to counter it.
Malak, this affidavit, Lordship. It is there. This is in fact the.
He says, I'm there.
Malak,
You can't help it.
I would submit, Malak, the Lordship may consider the record, Malak. It is before.
No. What is the record? That's why we put that question earlier.
True.
What would be a record for us? Is it the police investigation or it's an affidavit before us, which will have more credence? That's
No, in fact, the FIR and the GD, those are before your Lordship.
huh? Of course. Okay, we'll take a short break and come back.
It's an affidavit, Malad, I would say, Malad, prepared by he did not notice possibly. He did not.
We don't.
He did not take it.
We're not forming an opinion. We're just putting questions.
Lordship, that's true. That's true.
I'll be dependent on my sister to guide me.
Lordship.
When we ultimately start formulating.
In fact, Malad, in many affidavits I have seen, in this affidavit also, annexure so and so, they have written, but the annexure is not available here. I would, Malad, fairly say.
There's a reason for that.
Well, I would fairly say, Malad.
No, there's a reason for that. The reason is that the instructions are received by A, draft is made by B, and therefore they just copy and paste, they give it to a typist.
True.
And the typist does the real drafting. And therefore, annexure so and so, everything gets typed out.
Yes. But some of my colleague, my lord, it is because I have to take the burden, my lord. It was done by some of my colleague. It happened, my lord.
No,
In
whatever
fact,
but this is something we have experienced.
that's true. That is the going on, my lord. We
And
have,
that's why that continuity is not there. Affidavit of 5 is filed by A, affidavit of 6 is filed by B, and therefore this two of them they don't sit. It's
Malad-
just like what you call practice in medicine which goes on here.
So-
Two doctors don't consult each other and they independently look at the patient.
they
And
have to give their own
ultimately, the patient has to go out of state and then get treatment and come back.
on last 2-3 occasions, Lordship has indicated these things, my lord. That is why I have read all the evidence so many times, my lord. I have read the evidence so many times. That's true. My lord. It's our mistake.
Yes.
My lord, as regard the pleadings in the writ petition, I have taken your lordship to the affidavit of the respondent number 5 and 6. 6 is important for us. 5 2 paragraphs I have my lord, indicated. Then my lord, the status report of investigation of police cases, my lord, we have placed. There, my lord, the report of the inquiry report of the submitted to the district magistrate is there. The independent inquiry report, lordship has seen. Independent investigation report is there. Lordship has seen that. The ADC has the ADC, my lord, PC Burman ACS ADC on 4/5/2017 has submitted a report before the district magistrate. That report, my lord, we have placed with our instruction. It's a detailed report, my lord. I would like to refer to the report, my lord.
Which page?
But it was but by our letter dated 27/11/2024, pursuant to your lordship's order, my lord, we submitted. By SP Kokrajar, by letter dated 27/11/24. Along with that, the report is approved.
27/11/24.
Letter is 27/11/24. We submitted, my lord.
Yes. Yes.
The SP by that particular letter has apprised the status of Kokrajar PS case, and with that, my lord, the reports submitted by the ADC to the district magistrate is there. Page number 3 in that letter, my lord.
Page number 3.
Yes, my lord. This letter contains a bunch of paper. Page number 3rd page, my lord. The report starts from the next page. On 4/5/2017, this is addressed to the district magistrate Kokrajar. Has lordship got it?
Yes. Inquiry report.
It's an inquiry report
Yes.
of the ADC, no?
Yes.
This has, with reference to the above, I have the honor to submit here with the inquiry report in connection with the death of Ratan Narzari by Kokrajar PS case number 734 of 2016. But he said that one, a report received from SP Kokrajar by letter number so and so dated 30/12/2016 regarding request for causing ministerial inquiry. Reference number so and so for Kokrajar PS case number 734 of 2016 under section so and so. Based on specific input regarding movement of NDFB cadre at village so and so, a joint operation was launched by Kokrajar police led by Srijit TP, additional SP headquarter, Kokrajhar SI Ritura so and so, and 7 Sikh LI Army camp so and so at about 1:30 p.m. Time and the who has led the team, that is Murad, I would like to indicate. The operational team reached the village Laupani and were to lay ambush at 2 straight points. One are to be laid by additional SP headquarter Kokrajhar and his team, and the other to be led by IC Bishumari PP along with a team of 8 APBN personnel and one section of Commando Battalion personnel. Yes, ma'am. At about 5:20 hours, 3-4 suspected cadres equipped with sophisticated weapons were observed approaching towards west from eastern direction through a jungle track. While observing the suspect who were moving towards the ambush party, they were asked to halt. Immediately, the cadres started indiscriminate firing upon the operational team, finding no other alternative than in self-defense, as well as for protection of government property. The operational team also opened controlled retaliatory fire. The exchange of fire lasted for almost 20 to 25 minutes, and after the firing stopped, the operational team waited for 10-15 minutes to observe the area for further movement. Thereafter, the operational team cautiously searched the area and found one severely injured militant lying in the jungle, and other cadres managed to escape, taking advantage of thick forest. Immediately, the militant was evacuated to RNB Civil Hospital, Kokrajhar for his medical treatment, but the on-duty doctor declared him brought death at 6:58 a.m. Later on, the slain extremist was identified as Ratan Narzari, son of so-and-so. The following recoveries are made. It must be mentioned here that the slain militant was also an arms supplier, a peddler who, according to reliable intelligence output, had in possession of few deadly arms and hundreds of ammunitions that were of different caliber as per intelligence output from various central and state intelligence agencies. He was also attempting to peddle the ammunitions arms to the belligerent and arms derived deprived fugitive Badai Bata group of band NDFBS. This refers to Kokrajhar PS case number 734. The statement of Srijit additional additional SP headquarter Kokrajhar recorded in connection with Kokrajhar PS case number so and so. The statement of the SP has been quoted. Based on specific input from central and state intelligence agencies, which were further corroborated by ground sources on transaction of huge amount of arms and ammunitions among dared NDFBS cadres, namely Bedai, Batau, Khose, Birbai, etc. An operation was launched in General Laupani area on 27/12/2016. In the midnight at around 12 o'clock, I contacted SI Ritujuti Nath IC Bishumari PP as Laupani area falls under his jurisdiction. I also contacted Major so-and-so of 7 Sikh 1 Camp Ronikhata with the IC Bishumari, his party, and an army team from Sikh so-and-so. Accordingly, we reached Runikhata general area and asked all our vehicles to come near ride number 7 of Ultapani jungle. We walked further for another 5-6 kilometers in the northwest direction, and we laid ambush at a distance of around 60-70 meters. The army would plug exist route in the southern direction. So as we lay in wait for next 130 to 2 hours, we could observe movement of 3 men who were wielding large weapons. We asked them to stop, but without any provocation, they started indiscriminate firing upon us, having no choice except to fire back to save our lives in self-defense and also protection of the government properties. We fired in controlled retaliatory manner, and our parties engaged in firing for next 10-15 minutes. We lay in wait for next 10 minutes to observe the movement. After finding that there was no movement, we searched the entire area from where firing had come. Again on search, we stumbled upon a person who was injured and who had in his possession one AK rifle with a magazine and a black color shoulder bag. We immediately communicated with the driver through our VHF set. They were asked to come further east. The army personnel also had reached the point of firing, and I requested them to continue the search operation to nab the other miscreants who had managed to flee away, taking advantage of the darkness. As the vehicle had approached, as we quickly evacuated the injured person to RNB Civil Hospital, Kokrajhar, where the on-duty doctor declared the injured person dead. The slain militant was later identified as Ratan Narjari. Then the statement of the IO, Rupjyoti Nath, was also
Just a moment.
But they kindly come to serial number 4, WT message, so and so. The intelligence output received indicates he has noted the intelligence output as regard we have also indicated. The intelligence output received indicates that NDFBS cadre Bansao camping with Bedai has contacted one NDFB linkman Ratan Narjari using cell phone number so and so regarding ammunition. According to the input, Ratan kept 1,000 rounds of live ammunition, of which 300 AK series ammunition and 700 so and so 16 are M16 ammunitions. Please develop the input and take necessary follow-up action with intimation to this headquarter. So that was by ADGP SB Assam. And the second input, they have the inquiry officer has noted intelligence output. This is dated 26/12/2016. Intelligence input received indicating that NDFBS cadre Khause operating from Nagaland is monitoring the procurement of arms ammunition for NDFBS. Khause contacted Ratan Narjari, who is using cell phone number so and so, same mobile number. For finalizing detail regarding supply of ammunition for NDFBS, Ratan Narjari assured Khause to supply 300 rounds of AK ammunition and 600 rounds of M16 rifle ammunition. This is the figure of the witness which I have read. He has also indicated. Please develop the input and take necessary follow-up action. This was the report. Then the statement of wife that has been noted, my lord. The wife of the victim, I swear to speak the truth. She said, my husband was engaged in agricultural activities. He did not have any close friend. I did not know his relation with any unknown person. I am not aware if some unknown person had contacted my husband. He went to the market on 27/12/2016 alone from home, but he took the bike of our brother-in-law from the road. The name of the brother-in-law is Mohim Islari, and the bike is Yamaha Gladiator AS so and so. My husband did not return home on 27/12/2016. We could not contact him. At night on 27/12/16, we tried to contact him, but he did not receive the call. We contacted him from mobile number so and so with Ratan mobile number so and so. We recalled him again and again, but found busy. My husband did not call us back. We thought that he was busy in Christmas celebration and did not receive the call. We did not inquire about he was. On 28/12/16, Gaura informed us that Ratan was killed by police encounter. I assume that Jagat Brahma might have killed my husband with conspiracy. So that was her statement. Now the Anil Narjari, he is the petitioner before your lordship. The statement of Anil Narjari, kindly see. I swear to speak the truth. I am second elder brother of Ratan Narjari. On 27/12/2016 at about 4 p.m. my brother went to the market from home and he took the bike of our in-law for going to the market. I met him on the road. Ratan told me that his friend would come and he was going to market. I asked him to have a cup of tea with the public. He did not pay any attention to my request and he, along with one person on the bike, left to the market. While going to the market, he took one Susanto nursery with him. After that, leaving Susanto nursery alone, Ratan left the place to an unknown destination. Ratan told that somebody had called him and went to the bike and went on the bike somewhere. He did not say anything who called him. This may be noted, my lord, in my respectful submission, because in the writ petition while he has filed, he specifically said that Jagat called him. But he told the name of one Jagat Brahma alias Jaikra at his home. Sushanta Narjari came back home alone and informed that he did not know when Ratan would come back home. After that, Ratan was contacted in his mobile phone from home, but he did not receive the call, though his mobile was ringing. On 28/12/16 morning, Gaubura had informed that Ratan was dead. Then we went to Kokrajhar police station and saw the dead body in a vehicle. Then, the Mohim Islari, brother-in-law, he said that I swear to speak the truth. Ratan Nazari is my own brother-in-law. On 27/12/16, Ratan came to my home and asked for the bike as some guest was coming to see him. After that, we three come riding the same bike. After passing some distance, he went to the market alone with my bike. He did not come back from the market. As he did not come back, I contacted him in phone, but he did not receive the call. It was 6:30 p.m. Again, I called him. The mobile was ringing, but found him busy. Once again, I called him, but this time his mobile was switched off. After that, no information was available. I thought he was busy in Christmas party and did not anticipate any untoward incident. On 28/16, I came to know that from the Gaupura that Ratan was no more. So these are the statements taken note of by the investigating officer. Then he has also taken note of a site map of the occurrence, FIR report, inquest report, postmortem report, seizure, FIR copy against Jagat Brahma. This is a FIR malot filed subsequently, and a report of SP in connection with Runikata PS case 68 of 2016. This case was filed by the wife of the victim. Then malot other materials also he has taken note of. Then he came to the conclusion at the next page, malot. In the light of the above, it is evident that this is Ratan Nursery, as per report, police intelligence agent was associated with NDFBS unlawful activities, and security personnel had an encounter with NDFBS cadre on 27/12/2016 and 28/12/2016 at Laupani forest area, where security personnel opened firing in self-defense as well as protection of government properties, and Ratan Nursery was killed in that encounter as he was involved in evil design of the outfield. So this is the report of the ADC below. Well, the other reports are also there, my lord. The inquiry report, the postmortem report, the evidences, the records of investigation, etc. It suggests that the deceased person had a link, my lord. He in fact is a part of the NDFBS. He is not a cultivator. He's not a common man, my lord, as has been claimed in the writ petition. And my lord, the incident took place, my lord, when the police retaliated, my lord, to the firing made by that group on that night. Therefore, my lord, it's not a fake encounter as alleged in the writ petition. So for the guidelines of the Honorable Supreme Court, my lord, as my lord has been urged by my learned senior friend for the petitioner, as per the Supreme Court decision on 2014 10 SCC 635, paragraph 31, it has been complied, my lord. If lordship kindly for a moment takes off that particular guideline, paragraph 31 of 2014 10 SCC 635, this is People's Union for Civil Liberties. Yes, my lord. Paragraph 31, this is the guideline, my lord. Our case is that we have, my lord, complied with that. We have followed that.
Please read it, Mr. Chaudhary. I
Yes.
think I had given it.
Yes, yes, my lord. Well, paragraph 31, it says, in the light of the above discussions and having regard to the
SCC.
yes, my lord. 2014 10 SCC 635. This is 2014 10 SCC, page 635. People's Union for Civil Liberties and another versus State of Maharashtra. Paragraph 31, my lord, it says, my lord, that in the light of the above discussion and having regard to the directions issued by the Bombay High Court, guidelines issued by the NHRC, suggestions of the appellant PUCL, amicus curiae, and the affidavits filed by the Union of India, the state governments and the union territories, we think it appropriate to issue the following requirements to be followed in the matter of investigating police encounters in cases of death as the standard procedure for thorough, effective, and independent investigation. Then 31(1) says, whenever the police is in respect of any intelligence or tip-off regarding criminal movements or activities pertaining to the commission of grave criminal offense, it shall be reduced into writing in some form, preferably in case diary or in some electronic form. Such recording need not reveal detail of the suspect or the location to which the party is headed. if such intelligence or tip-off is received by a higher authority, the same may be noted in some form without revealing the details of the suspect or the location. Well, from 31.2, it says that in person to the tip-off or receipt of intelligence as above, encounter takes to that effect, that occurs, an FIR to that effect shall be registered, and the same shall be forwarded to the court under section 157 of the code without any delay. While forwarding the report under section 157 of the code, the procedure prescribed under section 158 of the code shall be followed. 31.3, it says, my lord, an independent investigation into the incident encounter shall be conducted by the CID or police team of another police station under the supervision of a senior officer at least a level above the head of the police party engaged in the encounter. Here, my lord, we have in the affidavit also we have stated the team conducting inquiry investigation shall at a minimum seek to identify the victim. Color photograph of the victim should be taken to recover and preserve evidentiary material, including bloodstain, art, hair, fiber, and thread, etc., related to the death, to identify scene witnesses and with complete names, address, and telephone number. Then, my lord, D, to determine the cause, manner, location, including preparation of rough sketch of topography of the scene, and if possible, photo, video of the scene, and any physical evidence, the time of death, as well as any pattern or practice that may have brought about the death. It must be ensured that intact fingerprints of the deceased are sent for chemical analysis. Any other fingerprints should be located, developed, lifted, and sent for chemical analysis. This has been done. Postmortem must be conducted by 2 doctors in the district hospital. Then next, my lord, any evidence of weapons such as guns, projectiles, bullets, cartridge cases should be taken and preserved. Wherever applicable, test for gunshot residue and trace metal detection should be performed. The cause of death should be found out, whether it is natural death, accidental death, or suicidal or homicidal. Then, my lord, 31.4 says a magisterial inquiry under section 176 of the code must invariably be held in case of death which occurred in course of police firing, and a report thereof must be sent to the judicial magistrate having jurisdiction under section 190 of the code. Then involvement of NHRC, we have already informed, my lord. The 31.6 injured criminal victim should be provided medical, my lord. This in our case, he succumbed to that, my lord. We took the victim to the hospital, but he was declared that. Then 31.7, it should be ensured that there is no delay in sending FIR, diary entries, panchnamas, sketch, so and so to the concerned court. So these are the requirements, my lord. Up to 31.9, my lord. In the event of death, the next of kin of the alleged criminal victim must be informed at the earliest. So these are the requirements, my lord. My lord, therefore, my lord, my respectful submission before your lordship is, lordship will examine, my lord, whether this is an encounter, my lord. He died in the police encounter. Now lordship will see, my lord, whether it is a fake encounter or it is a genuine encounter, my lord. There is a decision of this honorable court, my lord. It is reported in 2006 4 GLT 318, my lord. In fact, my lord, the learned 2006 4 GLT 318.
2006.
4 GLT 318, my lord.
Yes.
My lord, my learned senior counsel, Mr. B.K. Mahajan was the petitioner. This is a PIL. And my lord, as regard death of two persons, my lord, there is a PIL file in the court. And while deciding that, the court has, my lord, observed that the main legal points established that in the judgment that justification of police encounter under principles of self-defense and the duty of state to protect its citizen from terrorist activities. That was the main point, my lord. But I would like to, I'm referring this decision because incident of death was there. Two persons died. The contention of the petitioner was that the police could have ultimately arrested them. But the police has exceeded and killed them. Honorable court has not accepted that. I would like to just read some of the paragraphs of that judgment. Well, the facts are important. Little bit of facts will make it clear. Paragraph number 2. The two writ petitioners who are members of the Guwahati High Court Bar Association have approached this court in this public interest litigation for drawing attention to this court in respect of an incident that took place on October 30, 2002 within the heart of Guwahati city, which resulted in death of two persons, namely so-and-so and so-and-so, alleged to be members of a banned organization. Has Lordship gone?
Yes.
Okay.
ये इसको बड़ा कर देना है, पढ़ नहीं पा रहे हैं, झेल लेंगे।
The paragraph number 2 facts, my lord. Facts leading to the above incident as disclosed from the materials on record and which are not disputed are that one Abedur Rahman of Hatigao, a businessman, was subjected to extortion and some demands were made for extorting money from him. It may be mentioned that the said Rahman was earlier abducted from Kamalpur area and it is suspected or believed that he was released from captivity on payment of certain amount of ransom. On information being lost by said Abedur Rahman, he was kept under vigil and on the date of occurrence, the said Abedur Rahman was asked by the militant to proceed to a particular area of Hatigao Sareli. The direction was given over telephone and accordingly Mr. Rahman proceeded towards that place, followed by the police personnel in civil dress. While he was so proceeding, two persons were seen coming in a rickshaw from the opposite direction who started firing on the police personnel. Maybe they could realize the police personnel in civil dress. Police also opened fire and both the youth abandoned the rickshaw and started running towards Ajanta Path. The police chased them. One of the youth so-and-so fell to the bullet fired by police, but the other person entered into the residence of one Aftabuddin Ahmed and locked himself inside a room. There were some exchanges of fire between them and ultimately the other youth was also shot dead. In the meantime, higher police officials also arrived at the spot and necessary follow-up action were taken. The case of the petitioner is that the police had prior information. They could have easily apprehended the culprits alive. It is submitted that at least one of them, namely the second person, Mithu Borua, who was concerned in a room of a house, could have been captured alive, and killing of a person in inhuman manner needs to be deprecated. Moreover, after the killing, the dead bodies were removed in a most inhuman and indecent manner. Well, I'm not on that. That there was a mistake. Court has given a guideline to that effect. And petitioners have prayed for the following reliefs: to direct an inquiry to be conducted by CBI, to grant adequate compensation to the kith and kin of the deceased person, to direct respondent authorities not to kill a militant in unnecessary manner, and to take effective steps for training the police personnel to combat the urban and densely populated areas. So-and-so filed the DGP at the relevant time had filed an affidavit in opposition wherein the incident of October so-and-so 30, 2002 and had brought facts leading to the death of two persons have been admitted. It is stated that two militants first fired upon the police and in retaliation of which the police opened fire in self-defense. The respondent number 5, so-and-so the Dan SP Kamrup, and the respondent number 6, the so-and-so filed separate affidavits in opposition wherein the broad facts are stated above have been admitted. At this stage, it may be mentioned here that the Assam Human Rights Commission for short AHRC had taken so moto cognizance of the above incident, and AHRC case number 42 of 2002 was registered, and the commission gave its judgment by order dated 1/3/2005 at the direction of the HRC, Sri D.K. Bora, IPS Inspector so-and-so conducted a public inquiry and also collected video clipping which were recorded by TV channel media person. Sri Bora was not happy in registration of case at Dispur police station in respect of kidnapping of Muhammad Abedur Rahman, but the commission was of the view that Sri Rahman was kidnapped from Kamalpur area and as such, Kamalpur PS case number so-and-so under section so-and-so read with section 27 of the Arms Act had been registered at Kamalpur PS, and in view of that, law laid down by the apex court in TT Antony so-and-so, reported in so-and-so, did not find any fault with the SP so-and-so in giving direction not to register a case at Dispur police. So for killing of so-and-so is concerned, this is the first person. Speed Hazarika is concerned, there is no submission by the learned counsel that resort to firing by the police on him was unwarranted. It was, however, submitted that the second encounter leading to death of Mitu Bora could have been averted and he would have been apprehended alive. The learned counsel has drawn our attention to the report of D.K. Bora, Inspector General of Police, who found fault with the then SP in the manner in which Mitu Bora was killed. It is submitted that Mitu Bora could have been asked to surrender as he was all alone inside the house, and as such, he could have been made to surrender. The Assam Human Rights Commission, however, refused to accept the observation of Sri Bora. The video clipping were also seen by the Assam Human Rights Commission, and the commission observed as follows. We are unable to accept the above observations of Sri Bora in view of the circumstances which were prevailing at that time. The militant boys started firing, causing injuries to two persons, and even though he said that he could surrender, he did not do so in spite of asking by police to lay down arms and come out. According to Mr. Bora, second chance should have been given to the militant boy to surrender. This is also unacceptable to us in view of the situation prevailing at that time. There was no need for use of public address system, as the police party was just outside the room where the militant boy was hiding and not at a distance. Moreover, that he wanted to surrender was clearly heard by police, and he was given chance to lay down arms, which he did not. Sri Bora has referred to the video recording which had been sent to commission. Both of us have seen the video clipping, and we could see that all police party outside the room were very tense, which was normal considering the situation at that time, and nobody could know that other weapons like bomb, etc. might have been with the militant boy. Accordingly, we hold that the action taken by the police in the case of second encounter was justified. But my respectful submission referring to this decision is the fact situation of a case. That is the important thing Lord Lordship has to consider. Under what circumstances that was done. Only the possibility was there that he was in a room that should not be the reason that the police should have attempted that he should surrender. He should not have been encountered. But here, ultimately, the version of police that there was retaliation in self-defense, that was accepted by the Honorable Court. Although the investigation report of the independent investigation report suggests that some fault, it points out some fault to the police. It was not accepted by the Honorable Court. Ultimately, the Honorable Court has said that the fact situation which was prevailing at that time, that is the main consideration. Paragraph 9, my lord, because in these cases, my lord, ultimately the right to life and the freedom that has been urged. The Honorable Court has in paragraph 9 said that Lord Denning in his widely read treatise landmark in the law, while speaking on the topic when our freedom is attacked, has this to say: I trust that I have been as vigilant as anyone to preserve the freedom of the individual, but I have to confess that it has on occasion had to take second place. In our society, if our society is attacked by one or more, who would destroy us and our freedoms, then we must have the means to defend ourselves. We must stop them at every point of their attack. Before they launch their offensive, and after it is launched, if the danger is grave and imminent, we may have to detain them without trial. We may have to act as secret intelligence, and we may have to modify the rules of natural justice. All this may be necessary to protect ourselves, let we ourselves be destroyed. Well, the paragraph number 10, the situation as regard the second encounter was something like exercise of right of private defense of the body under section 100 IPC. The youth was armed and he was continuing to fire by keeping himself secured inside the house. And the police were concerned about their own security as well as security of the civilians. Retaliatory measure taken by the police at that point of time cannot be weighed in a golden scale, and the theory this far and no further could not have been applied. The police could not have taken the risk of losing life of other civilians, and we find that as a result of firing by the deceased, one civilian had already sustained bullet injury on his legs. So that was the prime consideration, that in the self defense it was done. But here in our case also, Malad, it was a retaliatory, Malad. It is the admitted position, Malad, that they were asked to stop, Malad. Ultimately, they started firing, and the police has started firing, Malad, in retaliation, targeting nobody, Malad. Ultimately, in indiscriminate fire, he sustained injuries, and he succumbed to that. And later on, he could be identified that he is Ratan Baswal. Therefore, Malad, my respectful submission is that the fact situation of a case, Lordship will consider and Lordship will see the legality of the encounter in that manner, Malad. But I have another decision, Malad. Malad, this is, Malad, 2013-14 SCC 290, Rohtash Kumar. Malad, in this decision, ultimately the encounter was found to be fake, and Lordship has, the Honorable Supreme Court has said that it is not a genuine encounter. But Malad, why I am referring to this decision? Ultimately, the Honorable Court has, Malad, laid down, Honorable, while examining what are the factors to be taken note of. That is why, Malad, I have referred.
2013-14 SCC.
Yes, Malad, 2013-14 SCC 290. 290. Paragraph 8.
Rohtash Kumar.
Rotesh Kumar. No? This is the Malad, the taste, whether it is a fake or it is a genuine encounter. Paragraph 8 to 16 are important, Malad. After carefully perusing the inquiry report dated 17/8.
We will continue some other day because we're already.
I have another decision, Malad. I'll place that and I'll make my submission that it is an encounter in self-defense. It is not a fake encounter.
Okay.
That is my
Endeavor.
submission. Endeavor. And these are the yardstick that has to be court will examine, Malad. The Honorable Court will examine while examining whether it is fake or it is a retaliatory encounter. JLP. It was 2006 4 GLB. On 8 after no, sorry. Getting देखिए भी यार वो 15 ना लगा
Each original and counsel for the petitioner is present. The each original and counsel for the petitioner, Mr. You are appearing for the Union of India?
Respondent number 1 to 3.
Respond for 1 to 3.
1 to
Okay.
4 to 8 I appear.
Okay. So B Decca, then CEC appears for respond number
1 to 3.
1 to 3. And anyone else is there? No.
No, madam.
Present. Next one.
4 to 8 I
The submissions of Mr. Dinath and the senior government advocate appearing for respond numbers 4 to
8.
8 remains inconclusive. List again on. The date we'll give after some time because
Logic.
there may be a disruption
Logic.
because of the APSC matter.
Logic.
The court master will give the date after some time.
Logic. Logic. I would pray, my lord, may not be on 9th or and 9th and 15th. May not be on 9th and 15th except 9th and 15th.
Except 1915.
9 and 15.
If this order is already on it, then you say we may also mention that due to some inadvertence in the error is crept in the order dated 24/4/2025. Stop. In one copy of the order, it has been mentioned that none appears for the petitioner. And in this second copy of the order, it has been mentioned that Mr. H. Ordinary Counsel appears for the petitioner. And he was heard. Stop. From the notings made by the court, Mr. H. Ordinary and Counsel for the petitioner was heard on 24/4/2025. So accordingly, the error which has crept in the order dated 24/4/2025 stands rectified by this order. Next paragraph, this one, so and so.
For further hearing.
Basic.
Sometimes it comes in different.
Further hearings.
Because I the history of.
Please remember that your
Section and postmortem procedure.
postmortem procedure.
Logic. I'll come up with that.
Please, your lordship. Today, what I have done yesterday, because we are running out of time, because time is very important factor for your lordship, for us also. There are other lawyers also. So what I have done today, for the convenience of the court, I have made a note. What is the point of argument which is proposition of law? Argument 1, argument 2, argument 3, argument 4. So I have made a note and also submitted a list of dates. And I have also prepared one index of pleading where which pages, which suppose I show, because here today I found that pleading is most important in this case. Most important pleadings, because I have to go with help of my learned friend. I have gone through almost lot of pleading because we are from lower courts, because pleading is very important in this case. Most important, because I have seen, my lord, honestly, when I moved the matter, I was before division bench, the situation was different. But when I have seen the pleading of the affidavit by the state and the another affidavit file is all contrary. different affidavit.
Mr. Das,
Yes.
just a passing remark, nothing to do
Yes.
with it. You see, you are proudly admitting about your connection with the trial court.
Yeah.
But now we are in a new regime where there is a class of lawyers who think that lower court, I don't practice there. So that's what is happening.
No, whenever some
No, not
juniors.
that, I'm just
No, it's
giving a
not
passing
fine.
remark.
No, whenever some juniors comes and they approach us, they say, see, I said that if you really want basic foundation of a case, you have to go before a trial court. The foundation is built before a trial court. That's what I understand that is what.
Yeah, true. It's true, but now we are in a different.
No, I remember, my lord, we have gone to Mohab Mestana also. That big book read. Now you don't have to circle office also. My lord, let us now give the notes to your lordship. Your lordship has seen the notes. Now your lordship will keep one hand the index of pleadings in one hand and the notes, that is preliminary notes of argument. Your lordship, my lord, Honorable Justice Malasin has got it. So kindly look into my preliminary notes of argument. And this yesterday, my lord argued this point. Now your lordship will leave at 4. 4 is the division bench, my lord. There an order which has been passed. I will go through that. But with what is most important, kindly take 6. See, next page 6. So, my lord, note, because I'll tell your lordship then, when the additional affidavit, as your lordship had asked, when the additional affidavit was placed before the division bench, then division bench has pointed out, my lord, to me, then Mr. Das, tell us whether whether the point was taken before the learned single judge or not. We said that this is not a new point. Additional affidavit we have brought because 9 pages tabulation sheet, which was before the government, because my lord, investigation was carried in 2016. 26/11/2016, they went and they have seized this particular document, 9 pages tabulation sheet. It was all before the government. So this is nothing new. They have, my lord, I will show it because I have to show, because basic thrust of the argument will be, my lord, the investigation which has been carried out by the state. That is a tainted investigation. This is my whole thrust of the argument. Now, my lord will kindly look into series 6. This is not a fresh argument. Kindly see that, not a fresh, because now your lordship doesn't have to make a note of it. Because not a fresh argument. The said argument was advanced before the learned single judge only. Only additional document had been filed as the appellant was not in possession of this document, which was supplied on 29/11/2021 by trial court, although the state was at all material time in possession of the same. Because 207, this accused, my lord, on 29/11/2021, they have received the copy. 207, they have received the copy under 207. Now, my lord, I will show when the division Mendid and Chief Justice asked, where is your pleading? Where is a pleading that if you have made? If it is not a new point, let us see your pleading. Now I will take your lordship to the pleading. Please look into the pleading, page 267 of the affidavit in opposition.
Of which brief?
Paper book, sorry, 96 of 2022. This is yesterday, this is a case, lead case, 96 of 2022. My lord, if your lordship looks into the index of pleading from 1 to 602, if your lordship has got the index, this is all the paper book. Because we have paginated all this, because running page. So kindly look into page 267. My lord, Honorable Justice Nandi has got it. Yes. My lord, the paragraph, I'll take your lordship to page 267. Para 44.
Page 44.
44, that's your lordship, the additional affidavit in opposition filed by the state, 251. It starts from 251. Lordship got it? 251.
Yes.
Now, 267, kindly see para 44. May I read this paragraph, my lord?
Yes.
Pursuant to the investigation being carried out, so far as 10 charge sheet, the initial charge sheet and 9 supplementary charge sheets have been filed before the concerned criminal court. Some of the said charge sheet demonstrating the role of the accused person whose role has been unearthed during the detailed and comprehensive investigation being carried out by the Assam police are also submitted in a seal cover for consideration of this honorable court. My lord, I will take later on. There are 2 affidavits which have been filed by the state. Now, one affidavit, my lord, that is their whole case. First affidavit is based on foundation. Now, when I'll show one order because I'm connecting to it. When, my lord, I was not before the learned single judge, my learned friend was there. When the argument, the final argument was to be begin before the learned single judge, the state came up before this court and told the court, my lord will give us a chance that so that we can bring notice some additional document before the court. Court by virtue of an order has allowed that. So the argument postponed. It adjourned. Now what I find, my lord, I was not handling this. What I find that this is an additional affidavit they have filed. Now completely a U-turn and making a different stand. Now whole case in the additional affidavit is based on motive, not on foundation. Earlier I'll read that earlier affidavit. I have gone through the earlier affidavit and it is based on the record, based on record. Second affidavit is based on legal advice. Without any verification. And whole case, that is why.
We did not get it. Please repeat again.
My lord,
We
the
did not get
earlier
it.
affidavit which they have filed, the first affidavit before the learned single judge was based on foundation. They said we don't want to enter into criminal culpability of any of the person concerned. No blameworthiness. It is only in respect what we have seen, overall public interest has been looked into it. So what we will not enter into. So that is their case in the first affidavit which they have filed. And it was based on a record. On record, based on record. 2 paragraphs was based on record. I will show that subsequently. Why I have said para 44, why I have taken to this, because the second affidavit which they have filed, this was not by virtue of the court's order. Court has only said that file some additional documents. Now they have filed a detailed affidavit. Now taking whole stand now is something else. Yes. My lord, I will, because your lordship is making a note of it, my lordship will kindly read that order. Has taken a copy out of it, because going through that record is again a big tough job will be that. Kindly see that both the orders.
No, now we have serialized it. This is the order sheet. We have
Yes,
made
yes.
it separate.
That's why I also thought that separately I'll.
The order of the
My lord, this is before the learned single
Oh,
judge,
acha,
this
okay,
order.
okay.
This is before the learned single judge.
Yes.
Kindly see 18/6/2019. Lordship got it?
Yes.
Mr. So-and-so learned today, though the matters have been listed for final hearing, number 2. Lordship got it?
Yes.
So-and-so Mahinder Singh, learned senior counsel for the official response submitted. It would be desirable to place on record certain relevant documents by way of affidavit in some of this petition, as affidavit in opposition could not be read in all the writ petition praised for some time to do so. On the other hand, so-and-so learned senior counsel for the petition submit, these matters have been specifically fixed today for final hearing, and as such, If these matters are to be adjourned to another date at the instant of respondent, necessary interim orders may be passed for suspending the impugn orders, as in some similar cases this court has suspended the discharge order. According to learned senior counsel of the petition on earlier occasion, when the prayer was made for suspending the impugn order, state has impressed upon this court that it would be the fitness of this thing that this matter be finally heard rather than considering passing any interim order or suspension of impugn order. It has been submitted. Accordingly, since the final hearing of the matter is postponed, impugn orders may be suspended. Heard learned counsel, so the court has felt it appropriate. Respondent may be given some more time to file the affidavit record by way of affidavit, whatever document they may be deemed appropriate before this honorable court. Only document by way of whatever documents they may deem appropriate before this court. According matter is fixed for final hearing, during which respondent filed the affidavit as mentioned above. So only liberty was granted only to file some additional documents. Whatever documents you have, bring it by way of an affidavit. Now they try to improve the whole case by filing the second additional affidavit. When I read, my lord, found that both affidavit is something else, it's contradicting each other. Now again, my lord, we'll go back to the list of the arguments, the note which I have given. Now, para 44 I have shown, my lord. Your lordship has read at page 267 of the paper book.
Yes.
267. Now our reply is at page 314. Kindly see our reply at 314. So this is the affidavit in reply before the learned single judge. See the affidavit in reply. So this is not a new submission or new thing which is new ground before the division bench. Kindly see para 39. Lordship got it? 314. May I read this paragraph, my lord?
Yes.
With reference to the statement contained in para 44. 44 is that your lordship is at page 267. Of the said additional affidavit, petitioner states and submits that the entire investigation in the instant case is faulty, motivated, and tainted with a blemish of malice, and therefore the consequent charge sheet filed in the criminal case are baseless, faulty, motivated, and tainted with a blemish of malice. Petitioner states and submit during the year 2013-14 and 2014 and 15, a total number of 421 candidates stood successful in the APS examination. Dibrugarh police took more than 35 months to carry out the whole investigation and submitted charge sheet and 10 other supplementary charge sheets. A total number of 74% have been named as an accused in the entire case. Out of the said 74 accused person, 60% are the candidates who were successful in the APS examination held in 2013 and 14 and 2014 and 15 and subsequently were appointed under various departments in the government of Assam. Therefore, it is a positive case made out by the Dibrugarh police that 361 candidates who also stood successful in the said respective examination have been legally appointed during the tenure of Rakesh Kumar Pal while he was the chairman of the APSC and therefore are deemed to be untainted candidates. Out of the said 361 untainted candidates, there are instances where several candidates have been deliberately left out by the Dibrugarh police to investigate for oblique reasons. The police authorities have investigated only selective candidates in a motivated and malified manner. In fact, from the records of the case, it is apparent that several candidates whose name had surfaced during the investigation against whom there was incriminating evidence were not investigated and they continue to remain in service. The Assam police, for oblique reasons, have chosen not to investigate such person. Therefore, it is amply clear that the investigation carried out by Dibrugarh police is a faulty investigation based on conjecture and surmises, and no reliance can be placed upon the various reports and or charge sheet filed by the said Dibrugarh police to discharge the petitioner from service by the state respondent. The petitioner crave leaves to refer to the records of the case at the time of hearing, if necessary. Petitioner denies and dispute that during investigation, any inculpatory evidence has been discovered against the petitioner. The petitioner states and submit on the basis of such selective, malafide, and vindictive investigation, the petitioner cannot be discharged from service, save as aforesaid, all allegations that are contrary thereto or inconsistent therewith are denied and dispute ex interim. So this is, my lord, we have already taken that particular stand in the reply.
But Mr. Das,
Yes.
if you take this plea,
Yes.
then the doctrine of the negative equality will set in. And because if somebody has not been investigated against, can that be a ground to interfere with the termination orders of the petitioner?
No, my lord, what has happened? This particular question was asked also, whether you can take the benefit of negative equality. But I will rather say what has happened in during the argument, deliberation was made before the division bench, then chief justice. This is what was asked. Kindly see now. The order of 29 order of the division bench. 29/9/2020 is already there. Kindly see the order of 29/9/2023. Lordship got it? 29/9/2023.
Yes.
Now,
Just a moment, let me assume sister.
yes, my lord, prior to that, my lord will kindly take up 24/9/2024 order.
24/9/24.
24/9/2023. Sorry, 27/9.
27/9.
Yes.
23.
27/9.
27/9/23.
Yes. See that first that.
Yes.
No. Lordship got it?
Yes.
Whether your lordship
just a
or
moment.
Nandi has got it.
Just a moment. I assume sister is getting it.
Lordship got it? Yes. Kindly see 27/9.
Yes, you got it.
The further arguments were advanced by so and so learned senior counsel appearing for the state of Assam. In the interest of justice, we hereby accept the prayer made by Kohli to file an affidavit in response to certain factual pleading in writ appeal number 96 of 2022, which seem to be over and above the pleading made in the writ petition. These additional pleadings have been made presumably because certain facts has come into existence knowledge of parties at a later point of time. Kohli shall keep the original record pertaining to decision-making process where the appellant herein were purportedly discharged available for the court's perusal by the next date of listing. Mr. Das, learned senior counsel representing some of the appellant, also praised that he may be permitted to bring two government orders on record by filing affidavit. He may do so. Request is made, so and so, so and so. Now come to next order. 29 order, 29/9/2023. 29/9/2023. Well, may I read this order? My lord, Mr. Das, learned senior counsel so and so is going to file as a totally, now my lord will read this, as a totally new development. Learned senior additional advocate general has placed on record a copy of the order dated 28/9/2023 issued by Director General of Police Assam, as per which a special investigation team has been constituted.
You're reading on which page?
29/9/2023 order.
Which page?
Page 22. Internal page.
Yes.
See,
2. Internal
as
page
a-
2. Yes.
yes. As a totally, lordship got it?
Yes.
Yes. As a totally new development, Kohli learned senior additional advocate has placed on record a copy of the order dated 28/9/2023 issued by Director General of Police, as per which a special investigation team has been constituted with reference to the letter of the Honorable Chief Minister of Assam dated 28/9/2023 to investigate the Dibrugarh PS case number 936 of 2016. As per the oral instruction received by so and so, the SIT is proposing to conclude this proceeding investigation within 6 months. We may note, during the course of submission, it was emphatic contention of the learned senior counsel representing the appellant investigating officer and the state official, while undertaking the so-called exercise of separating the grain from chaff, have acted arbitrary and with discrimination. While the appellant herein were signed out for punishment of discharge without any opportunity to so cause, others similarly situated candidate against whom investigating officer was possessed of significant evidence were left out. It was also contended two government employees, namely C. Nabakanta Patir and so, who were apprehended red-handed while accepting bribe so as to influence the selection process in question, have not been proceeded with, whereas the appellant herein, who were young freshly selected officer in 2013 APSC batch, have been discharged from service without following the principle of natural justice. The submission of learned senior representing the appellant were emphatically converted by so representing the state of SF. We feel that in order to reach to an appropriate conclusion in the matter, it would be opposite to direct the SIT constituted by order dated 28/9/2023 to give a pertinent interim report in a sealed cover on the following points for perusal of this court. 1. Whether the decision of the investigating officer to separate the cases of appellant herein and those candidates whose names are incorporated in the 9-page tabulation sheets is based on any logical rationale. Number 2, what was the reason for the investigating officer in not forwarding the document and the script of those left out candidates whose names are reflected in the 9 pages tabulation sheets to the FSL till 2019. 3. Whether the state government has proposed to take any disciplinary action against the left out officer whose names are reflected in the 9 pages tabulation sheets. 4. Whether from the evidence collected so far, any other case of securing selection by fraud has come to light. Now, my lord will kindly see the next 3 lines. Most important. Aforesaid observation shall not be considered to be adverse comments on the veracity of the earlier investigation report on the basis of where discharge order were issued as the appeals are yet to be finally decided. So, my lord, what has happened during the course of argument, deliberation with the earlier bench, when I have shown the pleadings and all this with 9 pages tabulation sheet, and the court said reasonable, there is visible manipulation, interpolation of the marks are there. He pointed out, what is this, Ms. Kohli, what has happened? Why this 1000 delay? Why you have not sent this 1000 FSL to the FSL? For 1000 days you have kept. Why you have kept? This is the first IO, my lord, where this investigation, where the learned single just said it commands acceptance. Why you have kept this for 1000 days? There is no answer. Second, he said, we have all the documents which we have annexed. We have shown it. 1000 days he waited. Then thereafter he sends it to FSL. My lord, FSL report was completed. 15 months he waited. He did not bring the FSL report. There is a reason behind why he has not brought. I will explain later on why he has not brought this. Why he has not brought this. 15 months after that he goes, then he collects it. And this after 2019, he gets it, but he might not, he doesn't, he collects it, he wait for 15 months and thereafter he collects. Now,
Then submits after 8 months.
he submits to the trial court after 8 months.
From the date of
Why?
election.
This is the court was asking. Why? Why you have done it? That is what your lordship was asking. Selectively, court said, no, we have to look into it. You have full doubt on the investigation which has been carried out. How your investigation is fair, we have to look into it.
The learned single judge decided.
Now, my lord will kindly see the learned single judge.
Mr. Das, you see, with all respect to the earlier orders passed,
Yeah.
but we are not entertaining a PIL.
This is
What do you call, in a writ petition filed by one of the aggrieved persons, can we order in proceedings of a writ appeal to make a fishing and rowing inquiry to direct the.
My lord, I will give a reply. Immediately I will give a reply to your lordship. Now, one, this is not a PIL, my lord. It is an individual who has come, this individual Why I have been discharged on a basis of a police report. PIL is this is not a PIL. This has been examined by the learned single judge. Paragraph 47, 48. My lord, why I am before this court, before division bench? What the learned single, the report was before the learned single judge. There is a comment made by the learned single in paragraph 47, 48, 49. Said that we have looked into it. The material that was placed before us, before the learned single judge, with a seal cover, with whatever material it was there. And the investigating officer has done a fabulous job. So it commands acceptance. Now today, it is not that your lordship will keep your eyes shut and see that what was in the left hand will agree to it. What is on the right hand, that also your lordship has to look into it. That's my respectful submission before your lordship. That is why this order was passed. I am asking myself, why this order was passed. Today, my lord, if your lordship,
You see,
because there is an answer to it. My lord, I will state, because I have to clear your lordship
no, I'll
doubt.
tell you, I'll show you something and then I'll point it out. That's it. Ready? I'm going to. Mr. Das,
Yes.
I would request you to look at the provisions of Order 26, Rule
Yes.
10(2). Order 26, Rule 10(2).
Yes.
This is commission for local inspection.
Yeah. 10(2).
Yes.
Yeah.
9, you are aware, it's commission for local investigation.
Yes.
9.
Yeah.
10 is procedure of the commissioner.
Hmm.
10(2) is report and depositions to be evidence in suit.
Yes.
Now I'm borrowing this for limited purpose in the writ petition.
Yes.
Although I'm conscious of the fact that under 144, writ petition is not covered by the CPC. But you see, the question is that when the court passes an order requiring something to be brought on record, that for all purposes becomes an evidence, even in a writ petition, because in writ petition, when it is by order of the court, I'll import the provisions from section 165 of the Evidence Act and say that the court has power to call for any document or anything from anyone, and nobody can refuse to produce. So once we exercise power under section 165 of the Evidence Act, directing something to be produced, then by virtue of order 10 order 26 rule 10 to it becomes an evidence, and therefore we are bound to look into it.
Yes.
That's one part. Therefore, I have a reservation.
Yes.
Why would the court, when it's not a PIL, when it's an intra-party dispute? Intra-party means one side it is a state and one side is the aggrieved persons who have been terminated. So if that be so, then why would the court require something to be produced and then have its acceptance by virtue of default? You see, that is the question I am always having.
But I'll give an answer.
Ah.
This is your lordship, this is a division bench. Earlier division bench already directed.
No, we
In
understand.
pursuance to that.
We
Now,
understand, but
now
those
whether-
are interim orders.
No, my lord will kindly look into it.
Those-
That is an order which has been passed by your lordship predecessor of this court. And only after satisfaction prima facie this order was passed.
That order is fine.
Now that your lordship, I'll give an answer to it. That order has attained finality. Now yesterday I said, now I have to go back to that to clear the mind of the court. To what extent? But I'll tell your lordship, my answer will be, it is not a PI. It is not a PI. It is a dispute between parties, private party along with the state. My lord, now public interest at large, what is said, it is involved. So we have terminated without going into culpability of any of the candidates. Now I'll tell your lordship, if a division bench of earlier predecessor has taken note of it, in pursuance to that they have filed an affidavit. My lord, before they could answer the question that was put by the court to them because of my argument, they said no, in the morning they came and they said, we have formed an SIT. Mala, what is the reason of forming an SIT? Now the question is, now that order which attains finality, now whether, let us now examine whether your lordship will now say that no, I will not take up because this issue I will not take up. Because this is a sort of like a why it is, if it is a PIL, you would have taken up. This is not a PIL. Whether we could take up. No, it is binding on both the parties, Milo. It is not that binding on us. Binding. Now I'll show one judgment of this court because why this particular point was taken. Milo, I will show it. Milo. So let's see that. Now kindly see. I was ready, my lord. My lord, one paragraph will look it in the Singh Kalon. There I will take that it becomes a binding. Whether your lordship will retract and say that no, I can't take up this point.
No, not binding.
No, that point. That point of the order. Kindly see one paragraph of the judgment. Para 41. Because I thought of placing it, but
interpreting column.
yes, because I thought of placing subsequently, but when a query comes to the court, I have to connect with that case, my lord. Kindly see para 41. See para 41. My lord, one thing I just want to put a question myself. Fair investigation doesn't mean it is only for the state. Fair investigation applies equally to us also.
To everyone.
Everyone, fair investigation. Now, how it was dealt, kindly see para 41. May I read this? Your lordship got it, my lord? My Honorable Justice Manasi Nandi got it, my lord? In the Preet Singh Kalon case, my lord, I have given the judgment. Yes, sir? I am extremely sorry.
It's okay.
We'll kindly take this.
No, it's okay. We'll have it. We'll share it. Don't worry. Don't worry. Give it to Mr. Das. No, give it to Mr. Das. We'll share it. No issue.
See para 41.
Yes.
If the service of the appointees who had put in few years of service were terminated, compliance with three principles at the hand of the state was imperative. 1. To establish satisfaction in regard to the sufficiency of the materials collected so as to enable the state to arrive at its satisfaction that the selection process was satisfaction that the selection process was tainted. 2. To determine the question that the illegalities committed go to the root of the matter which vitiate the entire selection process. Such satisfaction as also the sufficiency of materials were required to be gathered by reason of a thorough investigation. Please mark this, thorough investigation in a fair and transparent manner. So there are, what I understand, there are three things which is important. It has to be a thorough investigation. It should be fair and transparent. Now 3, whether the sufficient material present enable the state to arrive at a satisfaction that the officers in majority have been found to be a part of fraudulent purpose or the system itself was corrupt. My lord, there are 3 things.
This is also recruitment here.
This is a recruitment process of Punjab. So this was not a PIL, my lord, it was a recruitment process of Punjab. So that is my answer to it, my lord. Now, my lord, your lordship knows when you do an investigation, it should be fair to all. Now, your lordship apparently, on the face of it, I am putting a question, is it fair? You have left out selectively. This is not, my lord, with great respect. This is a fair investigation has to carry it out. Now, there are 2 options. My lord, either a fair investigation, thorough and transparent. I am putting a question myself, is it a fair? Is it transparent? Why you left out?
They have framed you.
No, my lord, this judgment was followed in the latest West Bengal case, my lord. Now your lordship knows the background. I'll tell that was a selection process of 2016. That was the matter was taken up by the court, High Court of Calcutta. Ultimately, it went for division bench. They said, no, what we seen here, that we will cancel the entire selection process 2016. It went to this apex court, my lord. Apex court said that no, this judgment has to be strictly followed. They have to follow the judgment. So what it means, my lord? My lord, this has to be strictly followed. Now, if your lordship looks into it, I'll just read one line and I will show it later. Third, there must be sufficient material to support the conclusion that the majority of appointments were part of fraudulent the second, to determine whether the illegally committed go to the root of the matter and vitiate the entire selection process. Such satisfaction should be based on a reason and thorough investigation conducted in a fair and transparent manner. No, they followed the Inderpreet Singh alone. Following that, my lord, this observation was made by this three-pronged test as outlined by Sina J is appropriate and should be adhered to. So, my lord, the question that has been put, I have given an answer. This was not, they have gone through it. When it went to the apex court, they said, let us see whether it is a fair investigation has been carried out. They have looked into it. The learned single judges looked into it. All the material was paid. I don't know which material they have hid. They have not placed the all materials. If all materials would have been placed, why this all the candidates were shielded? That is why, my lord, when the division bench has taken up this matter, earlier predecessors have taken up this matter, this order was passed by the court. And my lord, what they have done it, immediately on the next day they came to the court and they said, the court said, we want an answer. The next day they said, my lord, we have formed an SIT. And interesting, my lord, when the SIT was formed, my lord, they have thrown the first investigating officer. First investigating officer, where, my lord, with great respect, because the learned single judge also went by the document that was placed. The learned single judge had all these documents been placed. My lord, had all these documents been placed, learned single judge ought not to have gone to it, my lord. All the documents. So, commons acceptance means the learned single judge has gone through it. Now, can your lordship now, with great respect, they said no, because this is one from a PL, I will not look into it, my lord. No, this was examined by the learned single judge. Examined by the learned single, he has gone through it, my lord. That is why after going through it, he said it commands acceptance. Today, if I can show it, my lord, it doesn't command acceptance. Then what is the end result, my lord? End result, your lordship has said that no. What is the segregation you have done it? First, it has to command acceptance. That means the investigation has to be fair, transparent, thorough investigation. Why you have left out? What investigation you have done it? And the state themselves has thrown the first IO. And my lord, interesting, I'll show it. Because what it happens, my lord, in the course of argument, I have to say to connect it. When it was thrown, my lord, the first IO, the IO, SIT again has second IO was they appointed. Second IO brought notice to the court. Second IO, my lord, when they came to the court and they said, these are the person we found, 2013 batch. My lord, about five, how many? Nine. Five. A person was, my lord, arrested and they were brought before the court. Now the court said, they have filed the charge sheet thereafter. And my lord, then the court has asked, this we see this IO, he has left out many of the accused through this IO, second IO. Now they appoint third IO by virtue of the court's order. Now in the court, my lord, they brought another 26% accused in the court. 26 they have named. Further 23. Then the court said, the trial court, you have left out 9. These are the 9 you have left out. How you left out? My lord will be shocked, and is a part of record. How they have said your lordship will be shocked. They said, no, what we have done, we have graded now. But 2013 batch, your lordship will please keep in mind. And their argument throughout in the affidavit is a colossal fraud. 2013. Initial entry, pre-recruitment, no notice is required. So, if my lord is saying negative, will not be applied to them. That's what I'm asking, will not be applied to them. 2013. When this 9, the court has asked, why you have not made this 9? His reply was that no. By cabinet decision, we have taken a decision in cabinet where we have 3 particular group category they have made. One is that the menu this over this what is it? One category
Enhancement of mark.
enhancement of mark. One is enhancement of mark. Now the court said, what is the enhance of mark you mean to say? This is they have enhanced. Like in our case, 50 marks. Now suppose for example, to get a seat in APSC or ACS, now suppose it is 700 or it is 600. Now a candidate gets 550. So 50 marks, 700, if you want 700, 50 marks. No, 50 marks is enhancement is there. Even he doesn't get a seat in this APS or ACS, allied service he'll get it. So there is no criminality of those candidates. This is, the court said, what reasoning you are giving it? A trial court. The other is also same on the same footing. But I'll show this petitioner falls on the same footing. What type of investigation you are doing it?
For 7 years.
For 7 years, my lord will kindly see 7 years. They were doing it. That is my whole argument before your lordship was at the very beginning that the police report, on basis where it has been discharged, yes, there are judgment of the Supreme Court. It can be done. But I'll rather say that this was not a fair investigation that has been carried out. It's a tainted investigation they have done it. Now that is why I've shown to you judgment immediately. That was not a Punjab recruitment scam. This is what the court has looked at. In one of the the entire batch was
Krishna there, like Krishna Yadav was Chakradhar, we will rely later.
No, later on we'll rely to judgment of the Supreme Court. O Chakradhar and Krishna Yadav. I rely. In one of the case, my lord, one of the case of Supreme Court, it said that you have done an excellent job in one of the case. CBI has done an excellent job. From peon to minister they have got. Peon to minister. Yes, it commands acceptance. You have done an excellent investigation. That was CBI. Excellent. So it commands acceptance. Now on the face of it, your lordship is a judicial now looking into the judgment of the learned single judge. Whether this judgment which is passed is whether it is a perverse, arbitrary, what judgment your lordship is examining the judgment. Now the judgment relates to a particular investigation that was on a police report where we were discharged. And the finding of the learned single judge was that it was based on an excellent job which was done by the investigating agency. So it commands acceptance. Two, we will say it doesn't command acceptance. Whether your lordship will not look into it, whether it's command acceptance or not. The learned single judge has gone through it. Kindly see, immediately your lordship will kindly see now. Immediately your lordship will see the judgment of the learned single judge. Then your lordship will find the judgment of the learned single judge.
Is 585.
585 of the paper book. See para 47, my lord. Page 585 of the paper book, or your lordship is holding a separate judgment of the learned single judge, but it is 585 in the paper book. Lordship got it, my lord? See, kindly see para 47, because I am connecting it, my lord, this judgment with the judgment of the Supreme Court. Indeed, there can be no hiding from the fact that the arrest and the material collected against the petitioner following the FIR dated 27/10/2016, registered as Dibrugarh PS case number so-and-so, has set the ball rolling. The investigating reports of Dibrugarh police were the foundation facts. the gravity of which was considered by the government of Assam in Personal A Department, which eventually resulted in impugn orders being passed, precedent by consultation with the concerned department, obtaining the views of Judicial Department with the approval of the highest government authority. The impugned actions are only in respect of a identified group, section of candidate who had appeared in the mains examination. Identifiable group are only those candidates where the duplicate answer script after substituting with their original answer script were recovered from the confidential examination branch of APSC as well as from the house of the chairman Sri Rakesh Kumar Pal. This identifiable group alone were discharged from service and against whom charge sheet has been filed. They are the 52 writ petitioner here and another 8 candidates who are not before this court. Allegations are with regard to criminal conspiracies resulting in tampering with the examination process for the benefit of the petitioner herein. Investigation revealed petitioner had indulged in unfair means for getting selected by paying bribe or an extraneous consideration, but certainly not on account of merit. There are cogent material on which the respondent authority derives satisfaction that the selection process through which the petitioner came to be selected and eventually appointed was tainted by fraud. Irregularities in the selection appointment of the petitioner being found at the threshold itself, can it say that the state action was not bona fide in discharging the petitioner from service and was it not the solemn duty of the state to take the impugned action for maintaining sanctity and in reposing faith in the system and public offices in relation to the affairs of the state government? Can it say that it was not open to the state government to act on disturbing revelations emanating from police investigation with regard to grave illegalities being discovered involving the petitioner during selection process, which illegality occurs well before they had entered into service? To reiterate, the discharge of the petitioner from service was not account of any alleged misconduct after appointment, but on discovery of fraud at the time of their entry into service. There is a clear dividing in line between a challenge made to an offer of discharge on the ground of misconduct during post-recruitment period and a challenge made to an order of discharge on the ground of irregularities and illegalities finding place relatable to a pre-recruitment period, whereas the former would invariably invite compliance of audio alterum pattern rule of natural justice and or compliance of the protection granted under Article 311 of Constitution. Later can fall within the category of exception to the rule of audio alterum pattern, particularly if they are reliable materials to reach as a satisfaction. Now kindly see, particularly if there are reliable materials to reach a satisfaction that insofar for the petitioner are concerned, the examining process and the selection was vitiated. Going to so and so judgment, it is only when termination seem to be founded on manifest misconduct, it will be punishment and will go to violate Article 311 of the Constitution in the absence of inquiry. However, as I observed above, argument of misconduct being the foundation are wholly misplaced and misconceived, inasmuch as discharge of the petitioner from service are not founded on phenomena of misconduct as is understood in service jurisprudence. Now, my lord, I will tell this when the matter was looked by the learned singer, and these are finding reliable materials. That means it was placed before the learned single judge. My lord, without placing, how the learned single judge will come to know? And identification of the group was also before the learned single judge. Identification of the group was before the learned single judge. My lord, and on the basis of this, they have segregated. My lord, all this was placed before the government. On the basis of that, they segregated. And they made 2 groups. One is tainted and one tainted. So the learned single judge has gone through all the material that was placed. So I am asking myself, what is the material that was placed? Is the material that has been placed before the learned single judge was sufficient now, and also the government to arrive that no, we are segregating. These are the tainted. What has happened thereafter? when this SIT was formed, how they were left, what is the investigation you have carried out? Is this a fair investigation? As per judgment of the Inderpreet Singh Kalon, is it a fair, transparent, thorough investigation? So, now, my lord, the government doesn't has believed this IO and thrown away this IO. Why?
But he wants the court to believe his report.
Now he want that your lordship will see the report and say that his report is transparent, fair report.
But the government has
But
confidence.
but why? But the government has lose the confidence on the first IO.
Why?
Second IO. That is, my lord, that is what the court, my lord, has asked them. That no, they came up before they can say, no, we are forming an SIT. Or they could have said, we are not forming an SIT. Why an SIT was formed? I'm asking myself, why they have formed an SIT? What was the necessity of forming an SIT?
Maybe IO was not made part of the SIT.
Now, my lord, will kindly see next paragraph 48. The Dibrugarh police reports, lordship got it? 48, para 48. Dibrugarh police reports following investigation are part of records and a compilation of the same has also been furnished before this court by so and so learned senior counsel during the course of hearing. It is seen illegalities and irregularities discovered in the selection had been scrutinized and investigated upon in respect of each of the writ petitioners. The detailed police investigation. Now, this is your lordship will kindly mark it. Detailed police investigation enabled to pick out the candidates who had unlawfully benefited. A mere perusal of the police reports leaves no room for doubt as to the thoroughness with which the investigation was carried out. Irregularities attributed against each of the petitioner are minuted, reinforced by statement made before the IO by such petitioners as available in the record, admitting to their complicity, having gone through the police report. The prima facie view of this court is that the same commands itself to acceptance. The question is, could such selection in respect of petitioner be acted upon in the manner of public employment? Now, my lord, the judgment of the see 49, para 49. Now, kindly see para 49. What you got it? 49. My lord, now taking a cue, third line, my lord. Taking a cue from Inderpreet Singh Kalon, fourth line, my lord. Taking a cue from Inderpreet Singh Kalon, this court would hold that if servicer appointees are to be terminated after having put in few years of services, what would be imperative are that sufficient materials have been collected on the basis of a thorough investigation in fair and transparent manner, that the illegal committees that have gone to the root of the matter, vitiating the selection of the appointees, and that the appointees must be found to be part of fraudulent purpose and or the system itself must be found to be corrupt. Now, applying the above principle, there is no denying the fact that again each of the writ petitions sufficient materials have been collected through a process of thorough investigation, and the materials so collected disclose grave illegality, so and so. So, my lord, the whole case is that this investigation has to be fair, transparent, and thorough investigation and fair and transparent. So, my lord, I will demonstrate that, my lord, I started, that's why your lordship has put, then I have given an answer to it. Otherwise, this was later on. Now, kindly now take up again, my lord, my pleading. Kindly take this second page, my lord. Note on the pleadings, my lord, on the argument. Note on the argument. (267) and 314 I have read, my lord. Paragraph 44, thereafter my reply, which your lordship found in 267 of affidavit filed by the state, additional affidavit. My reply in this proceeding was 314. Lordship got it. Now, in appeal, my lord will kindly see at page 25. Appeal, page 25, para 35, appeal. Appeal memo. Page 25. See para 35. The petitioner has further categorically stated at para 39 of the affidavit in reply. So, Lordship, affidavit in reply is what I have read, my lord, at page 314. Just mark that 314 page. This which we have quoted, because the court was asking us at the time when this affidavit was placed before the court. Court has said, Mr. Das, whether you have taken this point before the learned single judge. I said we have taken this point. Where you have taken? Then I have showed to 314. Now, my lord will kindly look into it. I will not read that. But this is what, my lord. No, my lord, will I just chapter 2 I have written. See chapter 2. What was my learned friend Mr. Chaudhary's argument before the court? I have made it 4 points he has argued. 4 points. One is applicability of Article 311 and principle of natural justice. 2 is stigmatic order visited with the civil consequences. You have applied the service law, which I have understood. And when you have applied the service law, it is automatic as amount is stigmatic. Secondly, order of discharge based on an unproven allegation. Well, this is yet to be, trial is not been concluded. Unproven. It's only a statement under 161. So these are not proven unless it has to be decided. And number 4, confirmation and deemed confirmation of service. It deemed confirmed. So I am agreement, my lord, with Mr. Chaudhary's argument, but later on I will try to add few later on. But I am on now with the tainted investigation which has been carried out. Now, what is the best case that has been projected by the state? Let us say the best case, their case which they have projected. They said there is no concept of deemed confirmation, my lord. In their affidavit they have stated. And the appellant were provisioner at the time of their discharge. Because my learned friend said 2 plus 2, it is 4. 4 years once you complete, there either is writing or is confirmed. 2 years plus 2 years. So their case is you are all provisional. So you cannot take the help of deemed confirmation. This is the best case which they projected. Number 2, the discharge can be done on the basis of a police report. This is their case. 3, protection of Article 311 will not be applicable when the entry into service is illegal. So what they are saying, one is a pre-recruitment and a post-recruitment. In a post-recruitment, if any misconduct is done, then yes, you are liable to get a notice on 311. But in a pre-recruitment, when is a colossal fraud, then you are not entitled to get any notice. And 4, they distinguish what is a pre-recruitment and what is a post-recruitment. I think this is the best possible argument which the state has projected before the learned single judge. Any earlier round of litigation also they have kept it. Maybe they have, my lord, a different stand has been taken by way of an additional affidavit. I told your lordship at the very beginning, their whole case was based on a foundation. Thereafter, they came up and they say it is a motive, where they were not given opportunity, but they have filed a detail totally reversing the earlier affidavit which there. I'll show you later on. Now, what is a broad argument which I'm going to advance before your lordship? There are about 7 points I like to place it before this court. One is that, my lord, first, a provisioner cannot be discharged on a basis of a tainted police report. Whether he is a provisioner, whether he is not a provisioner, if I can show that he cannot be discharged on a tainted investigation that has been carried out. This will be one. Secondly, my lord, the additional affidavit which was filed by the state in the writ petition, whether it could be taken into consideration by this court. The second additional affidavit which they have filed. Third, my lord, discrimination of the state to discharge the appellant on the ground of probity in public service and retaining other similarly situated officer, thereby creating a class within a class. Where now it is apparent, they have created a class within a class. My lord, in the criminal trial also, they are same batch, they are continuing with the service. So can you create? If 2013 is a colossal fraud, it is your stand which you have taken. Either you have to retain all, if this you cannot create a class within a class, or you have to, all will go. You cannot take a stand this way and that way. And I will great respect, my lord, with the greatest respect, I'll say the impugn now with great respect, I'll say the impugned judgment was obtained by fraud because all the documents was not placed before the learned single judge. Documents was not placed. Otherwise, the learned single judge would not come to a finding that it commands acceptance. It was not placed. Respectfully, I'll submit. Apparently, on the face of it, of 12/11/2016, which was before the state. 12/11/2016 was before the state, and I have produced before the learned division when predecessor, and he said there is a interpolation, a manipulation of the marks. Visible marks is there, which you have kept it with you, and you have not sent to the FSL also. So all the materials were not placed before the learned single judge. So that is my fourth. In judgment was obtained by fraud. 5. State action violative of Article 14. So, my lord, here I have divided. No reliance could be placed on a tainted police report as the investigation is neither thorough nor conducted in a fair and transparent manner. And next, arbitrary segregation of tainted and non-tainted candidates without any intelligible differential, fairness and equity. And principle of natural justice and Article 311 could not be dispensed with in a light of subsequent stand of the state in case of other similarly situated employees. Last, state action also violative of Article 21. These are the broad arguments, my lord. I'll make it a very quick, my lord, because I made a note, so it becomes more easier, my lord. Kindly turn to next page, my lord. The first argument, this is on facts. Lordship will kindly, Lordship is having this note, my note, yes. So this is what my first point before your Lordship is that even for the sake of argument, my lord, while without admitting anything on the point on whether it's a permanent employee or a provisioner, even of the argument of the state is considered its entirety on the basis of the facts and circumstances of present case. This leaves a very vital question to be decided by the court. Very vital. To me, it's a very vital. Well, first, whether the provisioner can be discharged on the basis of a tainted police report. Very, very important. Because principle of natural justice, if your lordship is satisfied, number one, your lordship has to come to a definite finding that yes, on the face of it, we have seen the investigate. Now, only I can satisfy to the extent that I have to demonstrate. On the facts, I have to demonstrate, on the pleading. Otherwise, your lordship will say what statement you are making. There has to be some pleading to bring. Whether you accept or you don't accept is something else. But I have to show them pleading. How the investigation, how it is carried out. Let us now first, my lord. Now your lordship will see the entire basis of the judgment that has been passed by the learned single judge was on the trust and belief of the IO, which they carried out the investigation. And they said it is a detailed investigation, a thorough investigation has been carried out. And that was projected before the learned single judge. That is why there is a finding. That is why para 47, 48 and 49 of the judgments, where the report was produced, the learned single judge was satisfied and said it commands acceptance. Which your lordship, I have read that, I don't want to repeat. The lordship can mark it, and it is already, I have written in the note 585 and 587 para I have given. Now, my lord, now this submission, to back the submission, my lord, state submitted documents of the criminal case in a seal cover before the learned single judge on the last day of the argument. That your lordship will have seen that the additional affidavit at page 267, para 44, they have mentioned on the last date. Without any opportunity, my lord, normally what happens? There is no inspection. Because their last argument was concluded, they said these are the records, it is a seal cover and they have placed before the learned single judge. So we also don't know what was their materials before the court. But that is why we said those materials may have not been placed, all the materials were not placed before the court. If these are the candidates, you see in their 2013-14, you mentioned 421 candidates, how you left out all these candidates? All this was before you. So how you left out? How you segregated? So they were not placed properly, all those documents. Maybe they have not placed the documents, certain documents were not placed before the. Now, my lord will kindly see. Then we received the documents, lordship and mercy. Then third, we received the documents from the trial court only on 29/11/2021, where your lordship we have mentioned in page 26, para 36. If your lordship looks into it, para 36. Kindly see at my memo of appeal, page 26. I have pleaded that.
Yes, you have shown
Lordship,
that.
I don't have to go through it. I have made easier. Your lordship can go through that pagination I have done. In the, my lord, now kindly, in the earlier round of argument, in the appeal proceeding, we demonstrated that the police report itself is tainted. Lordship has seen that, we have mentioned it. In that reply we have mentioned, and cannot be accepted as true and correct to discharge the appellant. That we have shown that. In page 314 we have shown it now. And that time the court was convinced with the argument and the state could not satisfy the queries that were put to them by the court. Because division bench, we have shown that. As a result, on the next date, my lord, the state considered argument and informed the court they have already formed an SIT to investigate the criminal case. In order, my lord, to verify the arguments advanced, then the Chief Justice has formulated 4 questions. Lordship has seen and directed the state to submit a report, wide order dated 29/2023. Most probably, my lord, the report is before this honorable in a seal cover. We made an IA also that it should be handed. Your lordship said we'll look into it. Deliberation of the hearing, we'll see it, whether the report is necessary or not. There was an observation also made in the said order from which is apparent.
Because Mr. Das, we are compelled to think over it. On the last occasion also I said, we are compelled to think over it because of the fact that once the investigation, but there are 2 ways of looking at it. Number one, if the investigation is complete, then you get a copy under 207.
Yeah.
Supposing the investigation is still incomplete for one part, then premature disclosure of materials will affect the criminal administration system. Because it will be a premature disclosure. Because what we understand from you is that the charge sheets are being filed in part.
But criminal investigation is at that time, it is completed.
Now it's complete.
Yes, yes, I have annexed the order.
Okay.
I have annexed the order.
No, it's okay. We accept it from you.
Yes.
But so
It
that is the
completed.
reason.
It is completed, investigation.
And therefore, there was a reservation to disclose materials which are available in the seal cover.
This is fine. At that relevant time, it was.
Okay.
I have annexed the trial course order also.
It's okay. We accept
No,
it.
no, I have to show that also. That is important, my lord.
No, we take it from you. We are
Yes,
not doubting your statement.
No, I will show it even when I have annexed it. Well, I have to show it because why I have annexed it, there is reason behind. I have reason behind. I will tell you, your lordship, why it is I have annexed it. Now, there was observation also made in the said order. From it is apparent that the veracity of the criminal investigation will decide at the time of final hearing because there is a finding by learned singer police report command itself to acceptance. Lordship got it, my lord?
Yes.
Now, my lord, now when this order was passed, these four the points, four particular points formulated, my lord. Thereafter, the SIT they have formed on the basis of the said SIT, my lord. They carried out the investigation. I told the first IO was thrown away, second IO also replaced by a third IO. And my lord, accordingly, the SIT has named 28 employees as accused who were shielded by first IO. My lord, have seen the note. As such, any further demonstration may not be required to show that the police report was tainted on the date of discharge of my appeal. And on this ground itself, my lord, my appeal with great respect, my lord, on the basis of the police report, which is a tainted investigation we carried, it should not stand at all, my lord. On the face of it, they have sealed it. And you are telling before the court that we have done an excellent job. And it commands acceptance. My lord, whether it commands acceptance, you have left out all those candidates who belong to the same 2013 batch. What the apex court said, thorough, fair investigation, transparent, thorough, fair, and your segregation, if you have done it, tainted and non-tainted, no problem. But your investigation itself is not fair, thorough investigation. Where is the question of a segregation? But am I clear to your lordship? So they have segregated. Today, if your lordship finds that this segregation, they could not have done it because of the investigation they have carried on the face of it. Now, I'll just demonstrate before your lordship, kindly look into it. Kindly turn to next page, my lord. Page 6, my lord. See, this is what I will demonstrate. How it is a tainted police investigation which has been carried out. My lord, pursuant to registration of Dibrugarh PS, dated the investigation was carried out in respect of 2013-14 batch on the allegation of corruption to secure public employment. The first IO conducted an investigation over a period of 5 years, 1 month and 25 days. Now kindly see, during the span of more than 5 years, the learned trial court was pleased to allow the prayer of the first IO for further investigation on 18 occasions. 24-1, these are the dates. Last your lordship will kindly say 19 to 2018, one date. This is by the Honorable High Court. But a matter came so far as bail is concerned. In that matter, the court said no investigation has to be carried out. 22 to all these dates. So they have taken 18 occasions for further investigation. During the course of investigation, 5 years, the first IO submitted first charge sheet 24-1-2017 and 11 other supplementary charge sheet till 21-12-2021. The first IO named 39 candidates of 2013 batch and 21 candidates of 2014 as accused. Out of total number of 421 successful candidate 2013, In 2013, 241 and 2014 is 180. So that leads to 421, my lord. Now, my lord, as a result of the queries put to the state by this honorable court during the course of final hearing in the earlier round of argument and the state inability to answer those queries after a gap of 1 year, 9 months and 10 days on 30/9/2023, Government of Assam constituted an SIT to complete the investigation of the Dibrugarh PS case number 936 of 2016. Now, while constituting the state SIT, the state lost its trust and confidence on the first IO and was compelled to unceremoniously remove him from the case and not even allowed to be a part of the SIT. The stand of the state with regard to the investigation conducted by the first IO prior to formation of the SIT is stated in para 88 of the affidavit in opposition. That is page 772. Your lordship will kindly mark this 772. If your lordship, just for my sake, kindly look into next page. Just look that, my lord. I'll just trouble that.
772.
772, my lord. Kindly the 772. This is a volume will be different volume. Volume it will compilation. Oh, yes, loose. 772. 772. See page para 88, 772 page. My lord, I'll just tell your lordship, this affidavit was filed when I was arguing the matter on the last day before the Honorable Dean and Chief Justice. It was last day this affidavit was filed because we made certain statement in para 40, 50, 55 of the appeal memo, my lord. We filed this 9 pages tabulation sheet, all we have filed it. Then the court said, then if you don't give a reply, this will be treated as a non-traverse. Doctrine of non-traverse will apply. So I think, my lord, that's the reason the court said whether you want to file an affidavit, they have filed this affidavit, my lord. On the last day of the hearing before the division bench, my lord. Now kindly see para 88, page 772. The contents of para 36 to 39, that is our writ appeal, are denied being incorrect, misconceived and misleading. All such averment made toward the IO and the investigating process are denied. It is vehemently denied that the IO of the case has suppressed material evidence to seal other candidates. It is submitted. Appellant herein has made a vague attempt to twist the investigating process and the thorough investigation conducted by IO, which has unearthed this colossal fraud of which all the appellant in the present batch of the matters are a party and beneficiary for the so my lord, on the day when they filed the affidavit, they were very happy with the first IO and they said this has done an excellent job. Then what has happened to those candidates which subsequently you have formed an SIT and IO you have appointed some IO and you have thrown the earlier IO and you say that it is we are denying or it was done an excellent job. So what stand they are taking, my lord? The stand which they have taken here, 28/8, my lord, this 28/8. This affidavit was filed on 28/8, 2023. And the same day, the SIT was formed. The SIT was formed on the same day. Am I clear to your lordship, my lord?
Yes.
Yes. I think Honorable Justice Marasi Nandi also, my lord, your lordship can please ask me also. If there is any query, your lordship can put me. There is absolutely no problem. And my lord will kindly see the affidavit, who has filed the affidavit. I have gone through it. Who has filed the affidavit? Kindly see. Taxation department has filed this affidavit. Department of, because this petitioner belongs to a superintendent of tax. He's holding the post of superintendent in taxation department. Affidavit filed by whom?
Finance department. Finance department.
That means he is aware of the investigation that has been carried out. Thorough investigation that has been carried out. I don't know. My lord, being a civil lawyer, I go through all this, my lord. I have seen. Who is this affidavit filed? Are you aware of it?
720.
Kindly say 720. See 720, the affidavit filed by whom?
Joint Secretary Finance.
Joint Secretary Finance. Commenting on the investigation.
He knows everything.
Hey, the investigation has been carried out properly, very nicely. He's saying that no,
IO has done it.
excellent job, he has done it. How he is commenting?
Page 720.
Kindly see 720, page 720, the affidavit.
And the state of Assam is not filing, 225. Respondent is 225. The civic expertise. State of Assam 379, 225 is filed. Commenting on the criminal investigation. I know everything
Yes.
about the criminal practice.
Also got it? Yes. Now, my lord will kindly look into another, my lord, the notes. Take the second, my lord. Page 7.
Mr. Das will have to continue some other day because we'll have to rise for the single bench.
Only one request. I don't know how your lordship will be the board, how many numbers will be there on the Thursday. Whenever your lordship wants to take out the
Thursday,
matter.
Thursday is 13th,
No, Lordship 8th.
15th.
Lordship is not keeping it this week, going to next week, Lordship?
Yes, next week.
Okay, Lordship. Thursday will be then 15th, Lordship.
I will just let my court master look at it. There are two special
Only
benches also coming
one
on.
Request. But my learned friend's mother's treatment is there. Is throughout his assisting me, my lord.
From 14
So
to 20.
only 14 to 22 will not be available. So only before that is possible or after that. Now, subject to what my learned friend Mr. Kohli.
If Lordship, I'm subject to Lordship's convenience. If it is 13th, at least Mr. Das can finish his submissions because I think he has advanced his submissions to a large extent.
No. 12, 13.
12th is a holiday, I think.
13th. Okay, then 13th.
13, yes. Let it be on 13.
Okay.
Lordship at 2 p.m. only, no?
You have to renew the request to take it up at 2 o'clock.
Of course.
Normally what happens, I know there may be a difficult because lordship is holding. If it starts from 10:30, then I'll be able to complete, but your lordship, I think there are some few other matters.
No, because foreigners tribunals people are in jail.
No, it's
Fundamental rights.
no,
they
it's no
claim.
problem, no problem.
Lordship would be keeping it 2 days, 13th and 14th like this time. Other councils to continue, Lordship?
12 is holiday.
Okay.
12 holiday.
13th, 14th, huh? Very good, Lordship. I'm so grateful. 13th and 14th.
Submissions of Mr. D. Das, Learned Senior Counsel, assisted by Mr. S. Das, Learned Counsel, for the appearance in WA 96 of 2022 remains inconclusive. List again. Two consecutive dates on 13/5/2025 and 14/5/2025.
Lordship, my colleagues assist me. Their names are the same, continuing from the first order.
Yes, we are copying and pasting it.
It's enough for me, grateful Lordship and ladyship.
My lord, only one request is being made. My lordship, is any doubt on it, please free to ask it so that I can give a reply to.
Yes, definitely.
That's why I like that your lordship put questions to me so that I can answer it so it's clear in my mind also.
Then you get
My
an
mind is.
then you
how-
get an opportunity to
mind
read
is-
us.
I was smiling at that, Lordship. Deeply obliged. Grateful, Lordship.
Supplementary item 1.
Both you. Both of you, this is a continuous default on my part to pronounce the order. So fix it for hearing, but I think I'll need about 10 days more time to complete it. So the order is that it will be for rehearing. In the meantime, I'll try to complete the order. I'm sorry, but this is a long default.
No, Lord, it can, it's understood.
Uh,
So Lordship is fixing any date, Lord.
I'll be fixing a date. I'm proposing to fix it on 20th May.
Lordship. Yes.
Either 20 May or 22nd May. You choose your convenience. Either 20 or 22nd. Because I'm
Otherwise, Lordship
simultaneously-
is not hearing.
I'm not hearing the
of
matter.
law. Yes,
You see, the reason is that since I'm also taking up this APSC series now,
yes, Lord.
that's that is the
Any date, Lordship,
20 then.
subject to convenience.
20. Single page. This will be interesting. As the it will have IC one. Mr. I. Karita representing the applicant as well as Mr. P. Nayak, Leonard, standing counsel for the Leonard counsel for the respondent are present. As the order is could not be dictated, could not be released, or the matter would require a rehearing. It's published again on 2/05/2025. I'll try to
Lordship.
come together.
Obliged.